They're in Microsoft land. Oh, wait, the interpreter. Give me a moment. All right.
How about you?
Yes. I'm gonna call the first case. 9:30. Franklin Maldonado, case number 19 CF 3243. Thank you. Good morning.
Peter Duncan for the state judge.
Good morning.
Easy. Throw in costs at the end of this. Where's this PS?
Just approach with a score sheet for this case.
Thank you.
For the record, Judge, the score sheet only includes count 2. Part of the plea negotiation is that count 1 would be null prost. Judge, I have one final thing before we get started with the plea. I sent defense an email last night. The plea form that they sent me did not include the mental health evaluation and treatment that we had agreed on. I didn't get a response, so I don't know if they sent a new one including the mental health eval.
Do you want to add that to?
This is not the attorney for the case, Judge.
Right. There was an email that was sent out this morning,
Um,
but that wasn't involving this case, so I did not, who's the defense attorney on this case? It's a private,
David Santiago.
David Santiago. He is not here.
Oh, I thought I heard him say something.
I think that was, see, maybe, Attorney Santiago? Good morning. Attorney Santiago, if you're there, or if you have anyone who is representing, your office? Okay, so I don't see his attorney. So at this point, I am going to recall that case.
Yes,
A
Judge.
moment, but I will make note. Did you send the attorney an email in regards
I
to?
sent him the email last night, Judge.
And I don't have the plea form, so I'm interested to have that though. So if you've got get an opportunity, maybe if you could send an email over.
I'll print it out for you, Judge.
All right. So we're just going to recall that case in a moment. Let's call the, sir. Good morning, officer. We are going to recall Mr. Franklin Maldonado's case in just one moment, okay? Thank you. Good morning. Ryan Montez Quiros, case number 2013 CF 1337.
Judge, we could just pass this, Attorney J. Reed, for the record, we could pass this just for one moment. I'm just having them finalize the plea form. I'll be done. Be ready in 2 minutes.
You're there? Good morning, attorney.
Yes, Judge.
Okay, I will definitely wait on you.
Thank you.
No worries. Mark Robinson Jr., case number 20 CF 2069.
Rose Rosas on behalf of Ms. Leon.
Have a plea form.
Yes,
That one can be for them.
Thank you.
Please raise your right hand, sir. Do you solemnly swear or affirm the testimony you shall give to this court is the truth, the whole truth, and nothing but the truth, so help you God?
So I have, let's see if we have a score sheet. We are ready to go for this plea. Is there any restitution order? Oh, look at that. All right. Attorney Olvera, we're going to go ahead. Can you hear and see us?
Yes, Judge. Can you hear me?
I can. All right. Defense Counsel Attorney Rosas, can you tell us what the negotiations were regarding Mr. Mark Andrew Robinson Jr.?
Yes, Your Honor. So in this case, Mr. Robinson will enter pleas of no contest as to both counts as charged. The proposed resolution is an adjudication of guilt, 364 days in the Osceola County Jail or 12 months Osceola County Jail and court costs.
I have 3 counts here. Is that correct that you have? I have a grand theft of a motor vehicle, I have a burglary of a conveyance, and I have a petty theft.
Okay, that's correct then.
State?
Yes, Judge.
All right. We can look. Let's take it. Mr. Robinson? Can you hear me?
Yes, ma'am.
Can you state your true name and date of birth today for the record?
Mark Robinson Jr., 11/8/89.
Okay. Mr. Robinson Jr., your lawyer tells me that you wish to change your previously entered plea of not guilty and enter a plea of no contest today. Is that what you would like to do?
Yes,
Are you suffering from any mental illness or emotional disturbance today?
ma'am. No, ma'am.
Have you been treated for any of those issues in the past, Mr. Robinson?
No, ma'am.
All right. How far did you go in school?
12th grade?
Do you read and write English?
Yes, ma'am.
Do you understand did you read and understand the constitutional rights on this plea form?
Yes, ma'am.
And are these your initials on this plea form?
Yes, ma'am.
What are your initials?
MR?
Thank you. Did you understand by entering this plea you waive and give up each of the constitutional rights listed on the form?
Yes, ma'am.
Did you review this plea form with your lawyer?
Yes, ma'am.
Did she answer any questions you may have had?
Yes, ma'am.
Do you understand the maximum penalty is 10 years of prison and 60 days in jail,
Yes, ma'am.
plus your court costs?
Yes, ma'am.
Okay. And the maximum sentence for the first count of grand theft of motor vehicle is 5 years. The second count for burglary of a conveyance, the maximum sentence for the felony, the 3rd degree, is 5 years. On count 3 for your petty theft charge, it's a second degree misdemeanor, and the maximum sentence is 60 days in jail or 6 months supervised probation, okay? Did you enter this plea freely and voluntarily?
Yes, ma'am.
Do you understand all the maximum possible punishments of this offense that I just listed for you on your 3 counts?
Yes, ma'am.
Are you satisfied with your lawyer's representation of you in this matter?
Yes, ma'am.
Good, she's been a great lawyer. Has anyone promised you anything other than what your lawyer has placed on the record today?
No, ma'am.
Do you understand if you're not a citizen of the United States, entry of this plea will result in deportation?
Yes, ma'am.
There's 4 pages to this plea. Is that your signature on the back?
Yes, ma'am.
Do you understand? Let's see, is there a driver's license? Okay. Are you aware of any existence of any DNA evidence that would exonerate you today?
No, ma'am.
State,
Not from the state.
defense,
No, Your Honor.
factual basis, state, please.
Yes, Your Honor. On July 20th, at approximately 7:40 a.m., law enforcement on 4070 Hickory Tree Road in St. Cloud in reference to a stolen vehicle. Upon arrival, law enforcement met with the victim, who stated that his 2017 Chevrolet Silverado was missing. The victim stated that there were items of value within the vehicle. Victim stated that the vehicle had OnStar location, and law enforcement used this to track the vehicle. It was found in Polk County. And upon arrival, the male was wearing a fire department shirt, black hat, black boots. Polk County officers made contact and post Miranda admitted to taking the truck without permission. Defendant was then taken into custody. Other items were also found within the vehicle that did not belong to the first victim. This incident occurred in Osceola County.
Thank you. All right. Mr. Robinson Jr., I will accept your plea today. I'll find that you are alert and intelligent and that your plea, is freely and voluntarily entered, that you understand the natures of your charges and that you are represented by competent counsel, whom you already told me today that you're satisfied with. I find that there's a factual basis for acceptance of your plea. Is there any legal cause why sentence should now not be opposed?
No, Your Honor.
State?
Nothing to state, Your Honor.
Anything that you would like to tell me today, Mr. Robinson?
No, ma'am.
All right, Mr. Robinson, I will go ahead and adjudicate you guilty. 12 months in the in the Osceola County Jail with costs and credits of
Mr. Robinson has 147 days.
147 days time served. Court costs will be paid through the clerk of court.
A court cost of $415, a teen court fee of $3, a cost of prosecution of $100, and a public defender lien of $100, which totals to $618.
When you get out of jail, you'll be able to pay those fees. I'm going to give you 90 days before you have to make your first payment of $50, okay?
Yes, ma'am.
If you can't afford that or there's some type of issues, make sure that you contact your lawyer or the court, okay?
Yes, ma'am.
Your Honor.
Anything?
I apologize. So just to clarify for the judgment and sentence, so he's serving the 364 on just count 1, and then I believe he's supposed to be credit time served on counts 2 and 3, if the state could confirm that.
State?
That's fine, Your Honor.
And I'm going to say it on the record, so repeat that, please.
So he's being adjudicated guilty on all 3 counts.
Correct.
On count 1, it'll be an adjudication of guilt, 364 days in the Osceola County Jail in court costs. And as to count 2, an adjudication of guilt, credit time served. And count 3, an adjudication of guilt, credit time served.
Can we write this on this plea form?
Yes, Your Honor.
Attorney Olvera, I'm going to have her write those items on the plea form, as the plea form right now is just indicating count 1. I think it's important to indicate those other 2 counts, okay?
Judge.
Give me 1 moment.
And the counts are concurrent?
Yes, and the sentencing will be, the counsel will be running concurrent. I just want, just so there's no issues. Mr. Robinson, what we're doing right now in the courtroom with your lawyer who is standing in front of me, we're just making sure that the record is accurate and reflective of what your actual counts are and your credits, okay? All right, so I'm gonna reread that on the record now, which is adjudication of guilt for 12 months, Osceola County Jail. Court costs and fees, we talked about the credit time served of,
147 days?
that's the count 1 with the grand theft of a motor vehicle, which is a 3rd-degree felony, maximum of 5 years. As to your count 2, which is the burglary of a conveyance, that count is also adjudicated guilty with credit time served. For your count 3 of petty theft, which is a 2nd-degree misdemeanor, maximum sentence of 60 days, 6 months, is a maximum sentence of 60 days in jail, pardon me, is also credit time served. State?
Yes, Judge, that's correct.
All right. Just, thank you very much. I have a score sheet and a restitution and DNA order. All right, anything further from the state?
Nothing from the state, Your Honor.
Defense?
No, Your Honor. How much time does Mr. Robinson have to start his payment plan or his costs?
I gave him 90 days from the date after, we get that on record?
Yes.
90 days from the date after he is released with $50 a month. And Mr. Robinson Jr., you have the right to appeal the judgment and sentence of this court, okay? Any notice of appeal must be in writing and must be filed within 30 days of today's date. If you cannot afford an attorney for purposes of appeal, one will be appointed to you, okay, sir?
Yes, ma'am.
Good luck, sir.
Nice meeting you.
Thank you, Your Honor.
Thank you. I am.
And this is with statewide prosecutor Rebecca Smith Hemmeroff. I believe she's on virtual, Judge.
She is.
Hi, good morning, Judge.
Good morning. Give me one moment, I'm just signing.
That's wrong. This is the right one. I'm not doing anything.
This is where I'm always confused. Do I put restitution is not a
This one I don't care.
leave it?
This is the one that I care. Okay.
We can go ahead and call it up, the next one.
Ryan Montez Quiros, case number 2013 CF 1337.
For the record, Attorney Jay Ruth.
Good morning, Attorney Ruth.
Rebecca Smith Hemmeroff for the state.
Good morning, Attorney Smith, Hamaroff. And do we need a Spanish interpreter?
No, Judge.
Okay. Good morning, Mr. Montez Quiero. How are you doing today? All right.
Judge, at this time, we'll draw our previous entered plea of denial and enter an admission to the violation of probation. I've gone through the entire plea form. He's initialed the first, second, and third page and signed the third page. The agreed upon disposition with the state includes an adjudication of guilt, court costs 18 months Department of Corrections, followed by 2 years of drug offender probation. This is a downward departure. Our calculation is showing that he has currently 399 days credit time served. I think the clerk can probably verify if I'm on track with that.
Okay, I don't have a plea form.
I have the plea form here that's signed, Judge.
Can
I
I-
can show you, and then I can send it, drop it off, or fax it over, or
No.
e-file it today.
Okay. Either of those.
And I did email the score sheet over. Does Your Honor have that?
I have the score sheet. Okay. So, can I see another plea form?
I do not.
The one I just had.
One for the last case?
And then if you can, send me information of his, the actual violations, the numbers, what could be right. That'll be. Robinson, yeah, I can kind of look at it, so I can see what things. All right. So let's just first start, since I don't have the plea form, can you make, is it all the information initialed for the defendant, the case number at the top? No, is there everything initialed and signed appropriately?
Yes, Judge, the first page is initialed, the second page is initialed, the third page is initialed and signed by my client, Judge.
Okay, perfect.
It's a fully executed plea form.
Okay. Great. I have the other ones here. Okay, and can you put the negotiation on the record for me today?
The agreed upon disposition with the statewide prosecutor includes an adjudication of guilt, court costs, 18 months in the Department of Corrections, followed by 2 years of drug offender probation. It's our understanding that we have 399 days credit for time served.
Can you tell me how much time served?
We're showing 401 days total time served, and for the violation of probation, 36 days.
401 plus how many?
It's 401 total,
Okay,
but the VOP, he's only served 36 days.
we'll accept the 401. I'll cross it out on the plea form and make that modification.
State?
That's fine, Your Honor. That was the agreement.
All right. Mr. Montez Quiros? Can you state me your name and date of birth?
Ryan Abel Montes Quiroz.
Your lawyer tells me that you wish to change. One moment.
Please raise your right hand.
Raise your right hand.
Do you solemnly swear or affirm the testimony you should give to this court is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Can you state your full name for me? Your name? I'm so sorry.
Ryan Abel Montes Quiroz.
Yes, and your date of birth?
January 11, 1979.
Okay. You're changing your denial into an admission today, and you are giving up the right to remain silent as to new law violations, but you can be compelled to testify as to technical violations. You're giving up your right to be presumed innocent until the state proves by preponderance of the evidence that you substantially and willfully violated your probation. You're giving up the right to have a hearing before a judge and have your lawyer represent you at that hearing. Lawyers can cross-examine state witnesses, they can call witnesses, and on your behalf, they can present evidence. You understand that you're giving up all those rights today by accepting and entering this plea.
Yes, Your Honor.
All right. Are you under any influence of drugs, medication, or alcohol today?
No.
Are you suffering from any mental illness or emotional disturbance?
No.
Mr. Quiros, have you been treated for any of those in the past?
We've been treated for
No.
Okay. How far did you go to school?
A year and a half at college.
Okay. Do you read and write English?
Yes, ma'am.
Did you understand the constitutional rights on the on this plea form that you're signing today?
Yes, Your Honor.
Are these your initials and signature on that plea form that's next to you with your attorney?
Yes, Your Honor.
What are your initials?
Yes.
What are your initials?
RN.
Thank you. To the violation of condition of the order, to violation of condition 5 of the order of probation by failing to live without violating any law and as a grounds of relief that the offender violated his probation. To the violation of condition 7 of the order of probation, using intoxicants to excess or possessing any drugs or narcotics unless prescribed by a physician. Those are the conditions you are admitting to. Do you understand that?
Yes.
Okay. Have you entered this plea freely and voluntarily?
Yes, Your Honor.
The maximum possible punishment for these sentences are, you have the score sheet, you have the plea form in front of you. What are the maximum penalties, Attorney Roth?
15 years DOC, $10,000 fine.
Thank you. 15 years DOC and a $5,000 fine. Do you understand that those are your maximum penalties for this offense?
Yes, Your Honor.
Has anybody forced or threatened you in order to get you to enter this plea today, Mr. Montes Quiros?
No.
Are you satisfied with your lawyer's representation of the matter?
Yes.
Good, he's a great lawyer. Do you understand by entering this plea, there will be no trial and that I will go ahead and enter your admittance today?
Yes, Your Honor.
Do you understand if you're not a citizen of the United States, an entry of this plea will result in deportation?
Yes.
Yes?
Yes.
Okay. And you admitted that you violated condition 5 and condition 7 of your probation.
Yes, Your Honor.
All right. And that condition is, 5 and 7, okay? Are you aware of any existence of any DNA evidence that would exonerate you today, Mr. Quiros?
The what?
Anything DNA that would say that exonerate you, say that you haven't done anything?
No.
State?
No, Your Honor.
Attorney Roth? All right, factual basis, state?
We'll stipulate to a factual
Yes, Your
basis,
Honor.
Judge.
Factual basis, state?
If this were to go to a VOP hearing, the state would prove by the preponderance of the evidence that on December 7th, 2020, the defendant had a positive urine screen for heroin. Those events occurred in Osceola County.
Thank you. All right, I will accept your plea today, Mr. Montez Quiros. I find you are alert and intelligent, that your plea is freely and voluntarily entered into today, and that you understand the natures of your charges, and you are represented by competent counsel, who we already talked about you were satisfied with. I find that there's a factual basis for acceptance of your plea. Is there any legal cause why sentence should now not be imposed?
No, Judge.
All right, adjudicate you guilty, 18 months of Department of Corrections with court costs, 2 years of drug offendant probation following that. And we've already discussed the time credit of 36 days and 401 total days. Is there court costs, fees?
Cost of prosecution is $100, and he currently has an outstanding balance, if you wanted to add that as well.
And what is that?
$6,214.18
For a total?
of $6,314.18.
Okay, I'm going to allow him 90 days to, after his 18 months of Department of Corrections, to start making some type of payment. And then at that point, it will be $50 a month. Do you understand that, Mr. Quiros, today?
Yes, Your Honor.
All right, anything else from the state?
No, Your Honor.
Anything else from the defense today?
Yes, Judge, can we include in the order that he shall report to probation upon his release from DOC at the Brevard County Probation Office? That's where he resides.
State?
No objection, Your Honor. And I'm sorry, Your Honor, one more thing. I believe there are some previous conditions on his last probation, such as no contact with co-defendants. The state would ask for all the conditions from his prior probation to be included in the new term of probation.
Can you print me out his prior?
That's agreed to, Judge. We understand.
All right, give me one moment. I'm just going to pull that so we can put on the record exactly what those said conditions were, so that Mr. Montez Quiros will understand what he has to abide by. He may have not remembered those said conditions that were on that pretrial release. So I'm just going to give me one moment, Attorney Smith, Amaroff, and Attorney Roth, and I'm going to get those for him, okay?
Yes.
All right, in the meantime, I will add on the record that he will report to the Brevard County Probation Office within 24 hours from his release.
Let me check.
Thank you very much. And then we'll also add that the original conditions of his probation, which are the following: no contact with the co-defendants. There was a curfew. Do you want a curfew?
I believe curfews are generally part of drug offender probation, so I would leave it up to his probation officer's discretion.
Okay,
They usually are included.
okay, there is did you hear that, Attorney Roth?
Yes, Judge.
Okay, there is a suspended license for 2 years.
He would have already,
Yep, he's already had that, there was no objection, and the only other thing that I see here, for conditions that we have not discussed were community service of 100 hours to be completed at 8 hours due within 60 days, so he should have already completed that.
Yes, that's completed.
So I don't see any additional items besides no contact with the co-defendant directly or indirect, with the co-defendant directly or indirectly. Is there anything else that you would like me to add, State, from?
no,
Okay, so the only addition that I see from the judgment and sentence were no direct contact indirectly with the co-defendants. Mr. Quiros, do you understand that?
Yes, Your Honor.
Okay. Anything else I can do for you guys today, defense?
No, thank you, Judge. I will e-file this plea form and send a copy to your judicial assistant.
Thank you very much. You have a wonderful day.
Judge, have a good day.
State?
Thank you, Judge. Nothing further.
Thank you. Have a wonderful day. Good luck, sir. All right. Here's Mr. Quiros' score sheet. I didn't see a restitution order. Or did,
I don't have anything from.
can we, did she, Attorney Kazura,
Yes.
do you have a way to get to Miss Rebecca?
Miss Rebecca?
The attorney that was just on?
Miss Smith Hammeroff?
Yes. Is that her name, Ms. Smith Hammeron?
Yes, I can send her an email.
Can you just send her an email that there is no restitution order?
Sure. Be happy to.
The restitution order is a part to have a proper, please. Thank you. So that's the only thing we're missing. So keep this one. We'll make sure that we have that.
Your Honor,
Yes.
if I just have her send it to one of the clerks, is that?
Yes, I would like it right now,
Great.
please. All right, so this is. We are waiting. And I don't know, I didn't. Mrs. Santiago is here, thank you. Let me go ahead and admit everyone. I don't put please on. All right, Attorney Brooks, the only one. Good morning, Attorney Santiago.
Yes, Your Honor, I'm here.
Do you, before we call up your case for Mr. Maldonado, thank you for writing that on your screen for Microsoft Teams. I haven't seen that like that. That's great. Anyway, sorry. Continue to do that. That's helpful. We don't have a plea form at this time. Did you email me one?
I emailed one to the state attorney, Your Honor, because I was under the assumption that he had to sign
Oh, he
it
did
first
tell
before
me.
when-
That's this one.
Gotcha. I received the plea form. I printed it out. I've seen a couple of issues with it. I just sent Mr. Santiago another email. There's a couple conditions missing.
Mr. Santiago, have you had an opportunity to check the email from the state attorney? If not, I'll give you a couple moments to do so.
I believe it was the mental health evaluation that was the issue. Is that it?
Did you receive an email from from ASA Donnelly? He spelled out some of those things.
I just sent another email 1 minute ago.
And another email about 1 minute ago, he's identified some things that that you may want to, I just don't want to do that in front of you. You may want to look at prior to
Okay.
looking at the plea.
Yeah,
And then you can just make a
Yeah.
response. I'll call the next case, okay?
Okay.
Is that okay with you,
Yes, Judge.
Yeah, that's
Attorney
fine.
Donnelly? Okay, thank you. And then you guys can, so we won't have you guys doing those things in front of everyone. Okay?
Anthony Rodriguez Irizarry, case number 20 CF 3002 and case number 20 CF 42.
We're on page 2 of the docket.
Rose Rosas on behalf of Mr. Rodriguez Irizarry on 20 CF 3002.
And Brock Shields, Office of Regional Conflict Counsel for Mr. Rodriguez Irizarry on 2020 CF 42.
Good morning, Attorney Brock, and I am looking at plea form. Thank you for the admission of violation. I am looking at a plea form for count 1 and 2. I'm looking at a score sheet, and I have a restitution order. Good job. I am ready to have everything that I need to successfully give a plea. Mr. Rodriguez,
Please raise your right hand. Do you solemnly swear or affirm the testimony you should give to this case is the truth, the whole truth, and nothing but the truth, so help you God?
is that an ID? Yes? Okay, I'm going to start off with 2020 CF 3002. And that is APD Rosas. Your attorney for that case was Attorney Rosa. She's here in the courtroom, okay? I'm going to ask you a couple of questions, but before we do that, I will allow her to tell me the negotiations.
Yes, Your Honor. So in this case, Mr. Rodriguez Irizarry will enter pleas of no contest as to both counts. And the proposed resolution as to both counts is an adjudication of guilt, credit time served, and court costs, and that's to run concurrent to 20 CF 42.
Okay? And the only thing I want you just to add here for me is count 1 and then count 2.
Yes, Your Honor.
State, the only thing, good morning, I'm just going to just have her write the just 2 separate counts on here. There's nothing really she's changing.
Okay, no problem.
Thank you very much. And is that the negotiations that she put forth on the record, that Attorney Rosas put on the record today, is that the negotiations that you are also aware of?
It is, Your Honor.
Okay, thank you. Mr. Rodriguez?
Yes, ma'am.
And I know that sometimes you also go by Rodriguez Irizarry, correct?
Yes, ma'am.
Okay. What's your true name and your date of birth?
Anthony Rodriguez, Irizarry, 11/2/91.
And your lawyer tells me that you wish to change your previously entered plea of not guilty and enter a plea today of no contest.
Yes, ma'am.
And to the following charges. 1, possession of controlled substance, which is a third-degree felony, maximum of 5 years. Count 2, possession of drug paraphernalia, a first-degree misdemeanor, with a maximum sentence of 1 year, 365 days. Is that what you wish to do today?
Yes, ma'am.
Are you under the influence of any drugs, medications, or alcohol, Mr. Rodriguez?
No, ma'am.
Are you suffering from any mental illness or emotional disturbance?
No, ma'am.
Mr. Rodriguez, have you been treated for those in the past?
The what?
Have you been treated for any of those in the past?
No.
How far did you go in school?
9.
Huh? I'm sorry, I didn't understand you.
9th grade.
9th grade, okay. Do you read and write English?
Yes, ma'am.
And you don't want a Spanish interpreter today, correct?
No, ma'am.
Did you read and understand the constitutional rights on the plea form, this plea form?
Yes, ma'am.
It's 4 pages. Do you remember initialing these 4 pages?
Yes, ma'am.
What are your initials?
R.
And do you remember signing the plea form on the back?
Yes, ma'am.
Now, you've signed as Anthony Rodriguez, so you go, both of those names you go by, correct?
Yes, ma'am.
Okay. Do you understand by entering this plea, you waive each of the constitutional rights listed on this form?
Yes, ma'am.
And you're taking this plea because you believe that it's in your best interest, correct?
Yes, ma'am.
And I advise you in understanding the maximum possible punishment for these offenses are 5 years and 5 years in prison and 1 year in jail, plus total maximum fines of $6,000 plus court costs, fees, and investigation could potentially be your maximum penalties. Do you understand that?
Yes, ma'am.
Are you entering this plea freely and voluntarily?
Yes, ma'am.
Has anybody forced or threatened you in order to get you to enter this plea today, Mr. Rodriguez?
No, ma'am.
Has anyone placed anything other than what your lawyer has stated today on the record?
No, ma'am.
Are you satisfied with your lawyer's representation of you in this matter?
Yes, ma'am.
Good, she's a great lawyer. Do you understand by entering this plea, there will be no trial and I will impose a sentence based upon this plea?
Yes, ma'am.
Do you understand if you're not a citizen of the United States, that entry of this plea, Mr. Rodriguez, will result in your deportation?
Yes, ma'am.
All right, let's see if there's any license.
Yes,
Yes, Your Honor, there's a mandatory 6-month driver's license suspension.
Thank you. Do you understand the entry of this plea will result in the revocation of your driver's license privilege for 6 months?
Yes, ma'am.
Are you aware of any existence of any DNA evidence that would exonerate you today?
No, ma'am.
State?
No,
Defense?
No, Your Honor.
Factual basis, please?
Your Honor, as to case number 2020 CF 3003, on February 14th of 2019, law enforcement conducted a search with the defendant and observed that he dropped an item by his foot, and they noticed that it contained a green leaky substance. After the defendant was detained, the defendant requested that the law enforcement officer give him a break because he didn't want to go to jail for the small bag. Miranda was read to the defendant, and the defendant advised that he bought K2, which is the street name person that cannabis from somebody that had just left. FBO Lee confirmed the substance to be a controlled substance, which was inside a small bag, Florida. And Your Honor, as to 20 CF 42, the violation of probation, let me know if you want me to look into the conditions.
No, we're going to do that second. There's the attorney that is representing him on that is Attorney Brock Shields, so I'm just going to do one at a time if that's okay.
Absolutely.
All right. All right, Mr. Anthony Rodriguez Izari, I find that I will accept your plea. I find that you are alert and intelligent, that your plea is freely and voluntarily entered today, and that you understand the nature of that you understand the nature of the charges, and you are represented by competent counsel with whom you talked to me about that you were satisfied with. I find that there's a factual basis for acceptance of this plea. Is there any legal cause why we should not impose sentence now?
Nothing from defense.
Anything from the state?
Nothing to say, Your Honor.
Okay. I'm going to go, anything that you would like to tell me today, Mr. Rodriguez Izari?
No, ma'am.
Okay, I'm going to go ahead and adjudicate you guilty with credit for time served and court costs. I'm going to run that concurrent to 20 CF 42, and that's to your first count of possession of a controlled substance. As to your second count, I'm going to adjudicate you guilty, and you have credit time served.
112 days.
112 days.
So he's sentenced to 112 days with credit for 112 days?
No, that's on his count 2. Count 1 is adjudication guilty. Is that accurate, Attorney Rosas?
So it should be an adjudication of guilt on count 1, credit time served on count 1, and then adjudication of guilt on count 2, credit time served on count 2.
Okay. We have that, Madam Clerk? Okay. Yes? Okay. Costs?
Court costs is gonna be $415 court costs, a teen court fee of $3, a drug case fine of $350, cost of prosecution of $100, a misdemeanor surcharge of $15, and a public defender lien of $100, which totals to $983.
So, Mr. Rodriguez, you have some court costs. And you can pay those to the clerk of court, okay? I'm going to go ahead and give you 90 days before you have to start making your payments, okay?
Yes, ma'am.
And then at that time, $50 a month.
Yes, ma'am.
Is that something that you can pay towards your monthly obligation?
Yes, ma'am.
Anything further from the state?
Yes, Your Honor. Would the court consider, after imposing the court cost on the next case, maybe the court cost payments can be consolidated so that rather than making two separate payments, you're just making one?
Definitely. All right, Mr. Rodriguez, you have the right to appeal the judgment and sentence of this court, okay? Any notice of appeal must be in writing and must be filed within 30 days of today's date. If you cannot afford an attorney for the purposes of this appeal, one will be appointed to you, okay?
Yes, ma'am.
You're going to stay here for me, and I'm going to do another plea with your other attorney on your next case, okay?
Yes, ma'am.
Thank you very much. Thank you, Attorney Rosas. Attorney Shields?
Good morning, Your Honor.
Good morning. I am, give me one moment. I'm going to sign some additional forms so that the clerk will have everything ready to go for entry, and then we'll go ahead and take your VOP.
That's fine, Your Honor. Just behind me is Miss Osha Hammock from the Florida A&M University School, College of Law. She's an intern with my office for the next few months.
Definitely. Good morning. How are you? Go Rattlers. One moment. All right. We got a DNA, we got a restitution order. All right. Good job. Everything is- Yep. And then I have his admission of violation, community control. And we can go ahead and call the next case. Oh.
Okay. Anthony Rodriguez Irizarry, case number 20 CF 42.
Brock Shields on behalf of Mr. Rodriguez Irizarry.
Lydia Morales on behalf of the state, Your Honor.
All right. Can you state your full name for me again, and your date of birth?
Anthony Rodriguez Irizarry, 11/2/91.
All right. We are here today on an admission of violation of probation or your community control. Your attorney tells me that you wish to change your withdrawal plea and admit violation to number 5. Can I have that? The information, please. Sorry. Thank you. To violation of condition 5 of the order of probation by failing to live without violating any laws by committing the criminal offense of an aggravated battery with a deadly weapon on July 23rd, 2020 in Marion County, which carries a total maximum penalty of 5 years in state prison. Is that what you wish to do today?
Yes, ma'am.
Are you under any influence of drugs, medication, or alcohol?
No, ma'am.
Are you suffering from any mental illness or emotional disturbance?
No, ma'am.
And have you been treated for those in the past?
No, ma'am.
How far did you go in school?
9th grade.
Do you read and write English?
Yes, ma'am.
Now, this is important, Mr. Rodriguez. Did you read and understand the constitutional rights on this 2-page plea form?
Yes, ma'am.
Did you read this plea form with your lawyer?
Yes, ma'am.
And did he answer any questions that you may have had?
Yes, ma'am.
Okay. Do you understand by entering this plea, you waive and give up each of the constitutional rights?
Yes, ma'am.
All right. And you are giving up the right to remain silent as to new law violations, but can be compelled to testify as to the technical violations. You're giving up the right to be presumed innocent until the state proves by preponderance of the evidence that you substantially and willfully violated your probation. You're giving up the right to have a hearing before a judge and have a lawyer represent you at that hearing. Lawyers can cross-examine state witnesses, call witnesses on your behalf, and present evidence on your behalf. Do you understand you're giving up all those rights today by entering this plea?
Yes, ma'am.
Okay? Do you admit you violated condition number 5 of your probation by committing the criminal offense of aggravated battery with a deadly weapon?
Yes, ma'am.
Do you, let's see, are you aware of any evidence of DNA that would exonerate you today?
No, ma'am.
State?
No, Your Honor.
Facts?
No, Your Honor.
Factual basis?
Your Honor, it would just be the arrest on the violation of probation. There was a case that arose out of Marion County. They did not proceed on the charges there, but we do have evidence to proceed on the POP hearing.
Okay.
We would agree with that.
And I saw those circumstances. Thank you, Attorney Shields. Anything further from the state?
No, Your Honor. I would just just want to clarify. There was only one score sheet that was submitted. Is that going to be fine, or did they need to?
I would like them separate. If you could.
Okay. If I can just have a moment, I'll be sure to get it to Miss Pitts and Miss Blair.
Okay.
It was a global score sheet originally. So yeah, I'll be sure to get that by the time we finish work.
All right, and the conditions that you've agreed to are to terminate probation. I can't, sorry.
All right, Your Honor. So my writing is not very good. So revoke and terminate probation. He would be adjudicated guilty. He has to serve 15 months in the Department of Corrections with credit for today of 373 days time served. That's to be followed by 2 years of a new term of supervised probations with all the original conditions from his previous probation.
All right.
And this is a stipulated downward departure from the state.
Yes, I see the stipulated downward departure. I do see adjudicated guilty for 15 months, 373 days, time served, 2 years. The new term of supervised probation and the following conditions remain the same. Can you send me? Give me one moment. Mr. Rodriguez, what we're doing is just making sure that you're aware of the conditions of your probation from the last time, as they're going to keep those same conditions of probation with your new plea, okay?
Yes, ma'am.
Okay. There's no restitution order?
No, or, there should be, but there is no restitution to be ordered, in 20 CF 42, those were all previously submitted at the original sentencing.
Thank you.
Technical error. It's not printing.
Okay, can you, we're just having some technical difficulties. Attorney Shields, can you please, for the record, place what his what his terms of his probation were that are remaining the same?
Yes, I'm pulling that up right now, Your Honor.
Thank
Just a
you.
moment. Yeah.
Just so that the defendant knows
Yeah.
what he has to do, so that we are not in a situation where he may not have known.
He is not to possess weapons or firearms.
1 minute, you're not to possess weapons or firearms? Mr. Rodriguez, that's an additional, that's a part of your condition of your probation that will be remaining the same. The next condition of your probation that will be remaining the same.
No contact with Freddie LaFuente.
No contact with Freddie LaFuente.
Yes, ma'am.
Next.
And it looks like it was just the court costs and his payments. I don't believe, I'm looking at the paperwork submitted at the time of sentencing. I don't see anything in terms of community service or anything else.
All right, Mr. Rodriguez, it's very important that you remain away from the person that we just named and that you pay your court costs, okay? Thank you very much. I'm going to ask you that if there's any appeals, you have the right to appeal the judgment, and it must be in writing. If you cannot have one, an attorney will be appointed to you for that particular cost. Anything further from the state? Defense?
No, Your Honor.
Okay, Mr. Rodriguez, good luck, sir.
Judge.
And pardon me, 1 moment.
Probation, how long after?
Mr. Rodriguez?
When he finishes DOC, he's going to
So
probation.
when you finish DOC, you're gonna have to go to probation. You're gonna submit to probation within 24 hours. So as soon as you get out, you gotta go and report to probation, okay?
Yes, ma'am.
That's very important.
How long is the term?
And the
Your Honor,
term,
just to make sure he knows he needs to report
2
here in
years.
Osceola County.
yes, Osceola County probation.
Yes, ma'am.
And that's 24 hours, okay?
Yes, ma'am.
All right, good luck.
Just to be
What?
clear,
Give me 1 minute.
2 years.
2 years, I thought I said that. I'll say it again. 2 years of your new term of supervised probation. That is going to be after he leaves from DOC within a 24-hour period. He's going to check into the Osceola probation. He has 373 days of time served and 15 months.
Okay.
This is a stipulated downward departure. And the original conditions of his probation are remaining, which is what we listed on the record. Okay? Of course. Anything further today from the state or defense?
No, Your Honor. I have one other case, Ms. Summers, if we can perhaps call her, so I can be on my way from other stuff.
What page?
I can wait.
Do you know what page on the docket that is?
Page 2, Your Honor. And she actually would be next because I believe Mr. Santiago, we got approval to get it reset.
Santiago's getting reset.
I thought so. I believe.
Yes, it got rescheduled.
Yes.
All right, so we're on page 3 of the docket. Summers, Stephanie. Attorney Shields will go ahead and take yours. Give me
Yep,
one
thank you,
moment.
Laura.
Quickly, Judge, just to, not sorry to backtrack again, for Anthony Rodriguez Irizarry, court costs, how did you want them being paid?
All right, did I not? Okay, so court cost is 90 days after, then he'll be paying at $50 each. No worries. So you let me know when I can, sometimes you tell me when you're ready, okay?
And Your Honor,
Everybody can wait. Mm-hmm, yes?
was the court cost consolidated for him, so he's only gonna be making one, monthly payment? Or
Correct. The court costs of it, they were consolidated together. So 90 days, $50 a month for both of those, the VOP and,
and for the new law? And then,
Correct.
was there, just so he's clear on it, does he need to pay it through probation, or is he just doing that with the clerks?
he's gonna pay it through the clerk of the court.
I just don't wanna cause any confusion down the road for him.
No, the more we clarify, the better for everyone, including the defendant.
And can I also clarify credit time served? I'm so sorry. I have 193 days plus 6 months.
It's okay. Officer,
Yes.
can you bring back Mr. Rodriguez Irizarry for me, please?
We just send him back to his area. We try to bring him back.
Okay. We'll just take a break. We'll take a 2-minute recess. I just want to make sure that everything's okay, guys, and so if the clerk hasn't gotten some information, I don't feel comfortable with him leaving without having that said information. We'll take a couple minutes so that he can get back, so that I can be on the record with him, and then I will restate anything that you want me to say again.
Okay.
Thank you very much. Let's just be thorough. Yes. I'm so confused on what the problem is. So if you could just help it. Hold on, give me one moment. Officer, thank you very much for getting, Mr. Can you hear me? Mr. Rodriguez?
Yes, ma'am.
Can you hear me?
Yes, ma'am.
I just wanted to let you know that your time period for making those payments are gonna run at the same time, concurrent. So you have 2 different pleas you took today, right?
Yes, ma'am.
But when you come out, when you make your first payment in 90 days of $50 directly to the clerk of court,
Yes, ma'am.
that payment is going to be for both of your cases.
So that means I pay $50 to be for both please?
That is correct. So we want to make sure that you're keeping up with your costs, okay?
Yes, ma'am.
Thank you very much. You have a good luck with you for the rest of the day. Thank you, guys. All right, now we're clarified on that. Now we can move on. Let's go ahead and take Attorney Brock's next case.
Stephanie Summers, case number 20 CF 2702.
Brock Shields about Stephanie Summers.
Stay. Okay,
Your Honor, trying to figure out whose that is. It is not my case. Do you have the docket up?
I'm on page 7.
Maria Morales will
Pardon
be
me,
on the
3.
signal.
Okay, it's Attorney Morales.
Thank you, Judge.
Thank you. All right. Got the form?
And this is going to be a plea to a misdemeanor, Your Honor, so no score sheet's required.
Correct. Okay, yep. Thank you. All right, Attorney Shields, can you please put the negotiations on the record?
Yes, Your Honor. Ms. Stephanie Summers is going to plead no contest in count 1 to the lesser included offense of petty theft with 1 prior petty theft. That's going to be a first-degree misdemeanor with a maximum penalty of a year jail, a year probation, or a $1,000 fine. She's going to be adjudicated guilty. She's going to be sentenced to 180 days in the Osceola County Jail with credit for time served today of 138 days. She's to pay court costs, cost of prosecution, a $250 regional conflict counsel lien, to have no contact with the victim, and count 3 would be null pros pursuant to the plea to count 1. Count 2 does not apply to her as the co-defendant.
Okay. The only thing I would add is just that count 3 wasn't on this plea form.
Well, right, count 3 is, because she's not pleading to that, we just put on the end of it, we
I
had
see
count
it.
3 at PD, yeah.
Has that been sufficient? Without actually putting the count, Attorney Shields, have you found that sufficient?
Yes, count 3, I have NPD, null pros, that's my writing for null pros.
All right, and what was count 3?
Count 3 was a petty theft M2, but because of
No,
the.
yep, I just want to make sure that the defendant knows exactly what that no pros was, that they charged, that was no pros. Sometimes they don't, they may not be aware, they may be aware. All right. State, is that the negotiations that Attorney Shields put on the record today, is that the negotiations that you were also aware of?
Maria Morales on behalf of the state, it is, Your Honor.
All right. All right, Mrs. Somers? Can you raise your right hand for me, please, today?
Do you solemnly swear or affirm the testimony you should give to this court is the truth, the whole truth, and nothing but the truth, so help you God?
I didn't hear you, Ms. Somers, I'm sorry. Okay. Ms. Somers, can you tell me your name and date of birth? And Ms. Somers, you're gonna have to speak up into that microphone a little bit for us, okay?
Stephanie Summers, 3/18/90.
Thank you. Your lawyer tells me today that you wish to change your previously entered plea of not guilty and enter a plea today of no contest to the following charge of petty theft with a prior, which is a first degree, excuse me, with a maximum sentence of 1 year.
Yes, ma'am.
Okay? Is that, you said that's what you wish to do today?
Yes, ma'am.
Okay, are you under the influence of any drugs, medications, or alcohol today, Mrs. Somers?
No, ma'am.
Are you suffering from any mental illness or emotional disturbance?
No, ma'am.
Ms. Somers, have you been treated for any of those in the past?
No.
Or how far did you go in school?
11.
And do you read and write English?
Yes.
So you don't need a Spanish interpreter today? Do you read and understand, did you read and understand the constitutional rights on the plea form that I'm holding up? Did you review this plea form with your attorney?
Yes.
Did he answer any questions you may have had?
Yes.
There's 4 pages to this plea form, and you've initialed each page. What are your initials?
SLS.
And you sign a signature on page 4?
Yes, ma'am.
Do you understand by entering this plea, you waive and give up each of your constitutional rights listed on the form?
Yes.
Did you read and understand the constitutional rights on the plea form?
Yes, ma'am.
All right. Do you understand the maximum possible punishment for this offense is 1 year in jail, $1,000 court fee fine?
Yes, ma'am.
You said yes, ma'am?
Yes.
Okay. Are you entering this plea freely and voluntarily?
Yes.
Has anybody forced or threatened you in order to get you to enter this today?
No.
Has anybody promised you anything other than what your lawyer has placed on the record today?
No, ma'am.
Are you satisfied with your lawyer's representation of you in this matter? Great, he worked hard for you today. Do you understand by entering this plea there will be no trial and I'll impose the sentence based upon this plea?
Yes, ma'am.
Do you understand if you're not a citizen of the United States of America, entry of this plea will result in deportation?
Yes, ma'am.
see, there is no driver's license. Are you aware of any evidence today that could exonerate you, Mrs. Somers?
No.
State,
No, Your Honor.
defense,
No, Your Honor.
factual basis? As to count one, count two is for the co-defendant, and count three, which was a petty theft, was nole pros. So
Yes,
just
Your Honor.
please to the count one.
On September 17th of 2020, the victim had gone to the 7-Eleven to withdraw some money from an ATM when the defendant and the co-defendant came walking towards him. His wallet was taken, and the cash that he had withdrawn was taken without his permission. All these events occurred in Osceola County, Florida.
Thank you.
Oh, I'm sorry. And Ms. Summers had at least one time, or had been previously convicted of petty theft in 2013 in Orange County, Florida, Your Honor.
Yes, thank you. All right, Mrs. Somers, I will accept your plea. I find today that you are alert and intelligent, and your plea is being freely and voluntarily entered, okay? I think that you understand the nature of your charges, and you've been represented by a competent counsel with whom you already told me that you were satisfied with Mr. Shields today. I find that there is a factual basis for acceptance of this plea. Is there any legal cause why I should not be able to impose sentencing?
No, Your Honor.
Okay. With that, we already discussed, it'll be 100, and adjudicate you guilty, 180 days with credit time served of 138 days. Madam Clerk, is that time served date accurate?
I'm showing 139.
We have 139, Mr. Shields, so I'm going to go.
That's even better. That's fine. Yes,
I'm
maybe
going
that was
to,
yesterday when I talked to Ms. Blair. That's fine. 139 is fine.
I'm going to use this pen, guys, and I'm going to put 139 on your plea form.
That's fine. We give you permission to do that.
No
Thank you.
problem, Your Honor.
All
Thank
right.
you.
I have court costs, a cost of prosecutor, a $250 lien, and no contact with the victim. Can you give me the victim's name?
Yes, Your Honor. The victim's name is Mr. Ronald Jones.
Mrs. Somers, you're not to have any contact with Mr. Ronald Jones, okay?
Yes, ma'am.
All right. And 200 if we did that. And how much is the court cost?
Court cost is $273, and the contract attorney fee is $250.
$273, and the contract attorney's fees were?
$250.
$250. Court costs and other costs will be paid through the clerk of court, Mrs. Somers. How much can you pay a month towards your obligation?
20.
$20? A month? Okay. Do you think that you could pay $50 a month?
Yes, Your Honor.
Okay, so we'll go ahead and put $50 a month, but I will give you 3 months before you have to make your first payment. So I will, 90 days, then you make your first payment of $50 a month, okay?
Yes, ma'am.
Do you think you'll be able to do that obligation?
Yes.
Okay. Anything further from the state?
No, Your Honor. Well,
Anything?
actually,
Sorry.
apologies. As to count 3, state will no cross count 3 as to Miss Stephanie Summers only at this time.
Oh, there's someone, okay. I didn't know there was, okay.
Yeah. Co-defendant is also charged in count 2, but not her.
Okay. And did I put that on the record? Did I say that?
Yes. So just to clarify, count 1 is for both defendants, but Miss Summers is pleading to a lesser included offense.
Correct.
Count 2 does not apply to Miss Summers.
Correct.
So it doesn't even need to be included at all. Count 3, which is the petty theft, would apply to both. But Miss Summers is not pleading to that. Stated is dismissing the charge as to Miss Summers.
Okay, so I did say those are the things in the record. I do just want to make sure, because there's a co-defendant in this case involved, Mrs. Somers, this plea is just for you. Okay, so that count 3 for that nole pros, meaning that charge is no longer applicable to you, is only to you. That's what the state has discussed and your attorney has gotten for your case.
Okay.
Okay. Anything else?
No, Your Honor.
Also,
If you have the right, Ms. Summers, this is the most important. You have the right to appeal this judgment, the sentence of this court, okay? Any notice of appeal must be in writing and must be filed within 30 days of today's date. If you cannot afford an attorney for purposes of appeal, one will be appointed to you. Is there anything else you would like to tell me today, Mrs. Summers?
No.
Good luck to you, ma'am.
Thank you, Judge.
Thank you. Have a wonderful day.
Thank
Have
you.
a great day, Madam Intern, and you've got a great mentor there. All right. There is no, yes, but there should be restitution. No. Oh, wow. Okay.
Your Honor, was it a VOP? Okay.
Someone got stuck. Sorry. I'm not. That was a okay. Yes, I guess there was no, the state didn't put a restitution for that case.
Was it only a misdemeanor case, or was it, okay. The order, Your Honor, is for DNA samples, and it also has a restitution section on it.
I didn't get that.
Right, so it's not required for county court cases.
So how does the victim get?
Was there restitution to be ordered in this case? Okay, if there's restitution to be ordered, Judge, then we can either do it on the form, or you can just orally pronounce it as part of the judgment and sentence. That's the way that they do it in county court. In all circuit court cases, though, there's a fingerprint and DNA requirement, and so we have a form that includes the restitution that gets submitted with the score sheet on every case.
I guess that the difference was it's the misdemeanor.
That's right.
Okay. Because I'm used to, Attorney Roses has given me that restitution order with all hers every time. Thank you. Yes.
just to clarify, on Ms. Summers' case, there was no restitution.
Okay. Perfect. Pass it out for the community. Attorney Donnelly, are we ready for Maldonado?
Judge, we're ready on Maldonado. I handed up a corrected score sheet. Or not, the score sheet's up there. I handed up a corrected plea form.
Okay, Franklin Maldonado, case number 2019 CF 3243.
Come on, I'll call you back.
Is there a fine? What's the maximum fine?
Maximum fine.
And does this say,
Yeah.
Attorney Donnelly, does this say 30 years?
30 years is the maximum sentence.
All right, we just need the maximum fine.
$10,000.
Thank you. I'm gonna just write it in if that's okay with everybody.
That's fine with the state judge.
Sorry. Attorney Santiago, how are you doing today?
Good, and yourself, Your Honor?
Great, okay. I have all of the required information.
Your Honor, if I may?
Give me one moment.
Okay.
Oh, there it is. Adjudicated guilty for clause 48 months. Attorney Santiago, can you please place the negotiations on the record? Sorry.
Yes.
Oh, give me 1 minute, Mr. Maldonado. Your client is the client that needs a Spanish interpreter. So I'm gonna get one on the line, okay?
Okay, Your Honor. also ask Jill about the headphones? Maybe we didn't know what I was talking about.
Morning, Your Honor. This is Theodore Leal, Spanish interpreter. The interpreter has been previously sworn, Your Honor.
Good morning. We are on case number 2019 CF 003243. The defendant's name is Franklin Maldonado.
Thank you, Your Honor.
Okay. He is in jail.
Thank you, Your Honor. Entonces, señor Franklin Maldonado, 19CF003243. ¿Me está escuchando, señor Maldonado?
Sí, correcto.
Oh, Your Honor, the defendant can hear the interpreter well.
Okay, thank you. Please state your name and date, pardon me, can you hold up first? Can you put your right hand up,
Levante la mano derecha.
Madam Clerk?
Do you solemnly swear or affirm the testimony you give to this court is the truth, the whole truth, and nothing but the truth, so help you God?
Jura solemnemente que el testimonio que dará ante este tribunal será la verdad, toda la verdad y nada más que la verdad. Correct.
All right, your lawyer tells me that you wish to change your previously entered plea of not guilty and enter a plea of no contest. Is that what you wish to do?
Su abogado me ha informado que usted quiere retirar la declaración anterior, cambiar la declaración de no culpable y interponer una declaración de no me opongo al cargo. ¿Es eso lo que usted desea hacer?
Sí, correcto.
Yes, correct.
And that is to the battery, aggravated battery, causing, it looks like, so one minute, there's 2 counts here, State, or are we?
Correct, Judge. The plea is only to count 2, aggravated battery on a person 65 years or older with a deadly weapon.
And what happened to count 1?
It will be null crossed at the end of this plea.
Can we write that on here, please?
Sorry about that, Your Honor.
Entonces,
I'm sorry, Attorney Brown.
entonces en el primer cargo la fiscalía no va a proceder, pero sí va a dar la declaración de no me opongo en el cargo de ataque agravado con una persona de más de 65 años con un arma mortífera.
I just like everything to be perfect so that no one has any issues, and that, more importantly, the defendant understands everything.
Sí, quiero que se haga todo perfecto, para que no hayan problemas, y también quiero que el acusado pueda entender todo completamente.
Okay, to count 1, that charge will be nolle pros.
El cargo 1, entonces ese cargo se va a retirar.
And you're entering a plea of no contest today to count 2, aggravated battery with a deadly weapon on a person 65 years of age or older.
Y usted va a declarar, no me opongo del cargo número 2 de una agresión agravada con un arma mortífera a una persona de 65 años o más.
Is that what you wish to do today?
¿Eso es lo que desea hacer hoy?
Sí, correcto.
Yes, correct.
Okay. Are you under the influence of any drugs, medication, or alcohol?
¿Está usted actualmente bajo los efectos de drogas, medicamentos o alcohol? No, no.
Are you suffering from any mental illness or emotional disturbance?
¿Sufre usted de alguna enfermedad mental o desequilibrio emocional?
No.
No.
Mr. Maldonado, have you been treated for those in the past?
Señor Maldonado, ¿usted en el pasado ha recibido tratamiento por problemas mentales?
Sí, correcto.
Yes, correct.
Judge, he's been treated for a mental illness in the past. He was in competency status for a long time and was sent to the state hospital. In June of 2020, he was found competent by Judge Wooten.
Thank you. Defense.
Sí, señores, que en el anterior recibió.
That's correct, Your Honor.
Thank you.
En el anterior recibió tratamiento por problemas mentales. Él antes había sido catalogado como que estaba incapacitado, pero él estuvo en el hospital del estado y ya a partir de junio 2020, hasta que el juez Wooten determinó que ya él estaba capacitado mentalmente.
Okay. How far did you go in school, Mr. Maldonado?
Señor Maldonado, ¿hasta qué año estudió usted en la escuela?
Universidad.
I went to university.
Okay. And do you read and write English?
¿Usted lee y escribe el idioma inglés?
No.
No.
But you are able to understand the interpreter today who is translating what I tell you, correct?
Pero usted sí pudo entender al intérprete que está traduciendo todo lo que le están diciendo, ¿verdad?
Sí, correcto.
Okay.
Yes, correct.
Did you read and understand the constitutional rights on the plea form?
¿Usted leyó y entendió los derechos constitucionales que aparecen escritos en el formulario de declaración?
Sí, correcto.
Yes, correct.
Did you go over the plea form with your lawyer?
¿Y usted revisó el formulario de declaración ya con su abogado?
Sí.
Yes.
Okay. Did you have him answer any questions for you?
¿Y el abogado le contestó las preguntas que usted le pidió?
Sí.
Yes, correct.
Are these your initials? No. Did you sign these 2 pages of the plea form?
¿Y usted firmó estas 2 páginas del formulario de declaración?
Sí.
Yes.
And do you believe that this plea is in your best interest today?
¿Y usted piensa que esta declaración del día de hoy es lo que más le conviene?
Sí, correcto.
Yes, correct.
Do you understand the maximum penalty for this crime is a jail sentence of 30 years and a fine of $10,000?
¿Y entiende usted que las sanciones máximas por este tipo de delitos serían hasta 30 años de cárcel como sanción máxima y hasta $90,000? ¿Entiende?
Sí.
Yes.
Are you entering this plea freely and voluntarily?
¿Está usted presentando esta declaración de manera libre y voluntaria?
Sí, correcto.
Yes, correct.
Have you been forced or coerced by anyone to get you to enter this plea?
¿Alguien lo forzó o lo coaccionó para que usted presentara esta declaración?
No.
No.
Okay. And has anybody promised you anything other than what the lawyer has placed on the record today?
¿Y alguien le ha hecho promesas diferentes a la que su abogado acaba de decir ante las actas?
¿Podría repetirme la pregunta, por favor?
Could you repeat the question, please?
Has anyone promised you anything other than what your lawyer, Mr. Santiago, Attorney Santiago, has placed on the record?
¿Alguna persona le ha hecho a usted alguna promesa diferente a lo que su abogado, el señor Luis Santiago, ha dicho ante las actas?
No, no.
Okay.
No.
Perfect. Are you satisfied with Attorney Santiago's representation of you in this matter today?
¿Está usted satisfecho con la representación del abogado Santiago en esta causa del día de hoy?
Sí, correcto.
Yes, correct.
Great. He has helped you out very well and is a good lawyer.
Sí, lo ayudó mucho, él es buen abogado.
Do you understand by entering this plea there will be no trial and I will impose a sentence based upon this plea?
¿Entiende usted que con esta declaración no habrá juicio y yo voy a imponer la pena una vez que se haga este acuerdo declaratorio? ¿Entiende?
Sí, correcto.
Yes, correct.
Do you understand that if you're not a citizen of the United States, entry of this plea will result in deportation?
¿Entiende usted que si usted no fuese ciudadano de los Estados Unidos, presentar esta declaración lo haría que lo deporten? ¿Entiende?
Sí, correcto.
Yes, correct.
I handed up to you earlier.
Yeah, he did. Right here. I think. Yeah, I'm just telling you I have it. I'm sorry.
I'm sorry.
Are you aware today, Mr. Maldonado, of any DNA evidence that would exonerate you?
Señor Maldonado, que usted sepa, ¿hay alguna prueba de ADN que lo pueda librar de culpa? Que usted sepa.
No.
No.
The state is not aware of any, Judge.
Defense,
La fiscalía tampoco, su señoría.
factual basis, state.
Fiscalía, fundamentos fácticos.
Yes, Judge. On September 11th, 2019, the defendant and victim, who is his 77-year-old mother, were watching TV.
Sí, su señoría, el 11 de septiembre de 2019, el acusado y la víctima, que es una madre de 77 años, estaban viendo televisión.
An argument ensued. At that time, the defendant took a knife from the table that he had used to cut an apple and stabbed it into the leg of his mother.
Se suscitó una discusión verbal y entonces el acusado tomó un cuchillo con el que había cortado una manzana que estaba en la mesa y procedió a proferir una herida en la pierna de la víctima.
The defendant was immediately apologetic, and an ambulance and law enforcement were called to the scene, at which point the defendant was arrested. All this occurred in Osceola County, Florida.
El acusado lamentó mucho lo que sucedió, se llamó la ambulancia, se llamaron a las autoridades, el acusado fue puesto bajo arresto. Todos estos incidentes ocurrieron en el condado de Osceola, Florida.
Thank you. Mr. Maldonado, I will accept your plea today.
Señor Maldonado, voy a aceptar su declaración el día de hoy.
I find you are alert and intelligent,
Noto que usted es atento, que es inteligente
and that your plea is freely and voluntarily entered.
y que está presentando su declaración de manera libre y voluntaria.
That you understand the nature of the charges and are represented by competent counsel whom you told me that you were satisfied with.
Es que usted entiende lo que estamos haciendo acá y que está satisfecho con el abogado que usted me dijo, que está satisfecho con el abogado competente que lo representó. Yes, correct.
I find there is factual basis to accept this plea. Is there any legal cause why sentence should not be imposed?
No, Judge.
Okay. Veo que fundamento fáctico para aceptar esta declaración. ¿Algo que me impida que yo imponga la sentencia? No, su señoría.
Anything state before I impose the sentence, and anything defense before I impose the sentence?
¿Algo más fiscalía o defensa de que antes de que yo imponga la pena?
Nothing from the state.
Nada de la fiscalía.
Your Honor, the only request is early termination after 2 years if all requirements are met.
I thought, so you,
So, interpreter cannot hear at all. Sorry, Your Honor.
sorry, so you have to speak up a little bit. The interpreter didn't hear you. You have to speak
Okay,
up.
Your Honor.
Yes.
Yes, the only request would be early termination after 2 years once all requisites are met for the probation period.
State?
Judge, the state is not taking, Mr. Interpreter, do you need to interpret that first?
Yeah.
No, Your Honor, if Your Honor could help the interpreter a little bit. The interpreter only understood that the only thing that they were asking was that in 2 years, and then the rest was just a
Oh,
big
no worries.
jumble.
Mr. Santiago, can you repeat it for the interpreter? You have to speak up quite a bit.
The only request, Your Honor, would be early termination after 2 years once all requisites are met for the probation term.
He asked for early termination once all the requisites are met for the probation period.
Lo único que pide el abogado es que se termine anticipadamente el régimen de prueba, que se pueda hacer de anticipado una vez que se hayan ya cumplido todos los requisitos requeridos por el régimen de prueba.
Judge, that was not part of our plea negotiations. The state does not intend to take a position on that at this time. When that motion is filed, the state will handle it then.
La Fiscalía no apoya realmente ese pedido de terminación del régimen de prueba anticipado. Sin embargo, eso será algo que tendrá que verse durante una especie de petición que se presente ante el tribunal, pero la Fiscalía no lo apoya.
Defense, did you hear that?
Barely, Your Honor, I apologize.
The state at this time is not, the state has indicated that that position was not something that was discussed during your negotiations. And at this time, he is not willing to add that to your said negotiations. But at any time period that you would like to file the motion, you can take it up at that time.
Okay, Your Honor.
Okay. And I paraphrased his words. Sorry.
Sí, básicamente la juez lo que hizo fue ese resumen, que la Fiscalía no estaba dispuesto porque no se habló de esa negociación de que se termine anticipadamente, pero habrá que hacer una petición.
Okay, today I'm going to go ahead.
I'm sorry, I have one more thing to put on the record. The state would like to put on the record that the victim was notified of the plea date and plea offer. The victim had no objection to the plea offer and is unable to be present at the plea date. We've also coordinated with the victim's daughter and the defendant's sister to ensure that he has adequate lodging when he gets out of jail and that he is able to complete his probationary term.
Si lo único que la fiscalía quiere que diga para que conste en las actas es que se le notificó a la víctima no pudo estar presente, pero sí se le había ya informado sobre la fecha, se le había ofrecido, ya se le habló sobre la oferta, no pudo estar aquí. También se contactó a la hija de la víctima, o sea, la hermana del acusado, y aseguró que él tiene ya su alojamiento asegurado para que pueda cumplir y terminar con su periodo de prueba.
Okay, I will adjudicate you guilty today, Mr. Maldonado.
Señor Maldonado, entonces hoy lo dictaminaré culpable.
I sentence you to 48 months of probation,
Le pongo entonces 48 meses bajo régimen de prueba.
you must take all your prescription medication,
Tiene que tomarse todos sus medicamentos recetados,
monthly written updates from outpatient services,
y tiene que tener la actualización mensual de servicios ambulatorios.
we need a mental health evaluation,
Necesitamos una evaluación de salud mental.
no weapons or drugs,
Se le prohíbe el arma, se le prohíbe el uso de drogas.
any mental health treatment that is needed from your evaluation, and or any treatment you are already in the process or have been ordered to do.
Usted cumpla cualquier tratamiento que sea sugerido después de la evaluación o que siga cumpliendo cualquier tratamiento que previamente se le haya ordenado.
No hostile contact with the victim. What's her name?
The victim's name is Carmen Cordero.
I'm going to write that here. Carmen. And can you spell the last name?
Cordero.
Mr. Santiago, all I did was just write the name of the victim underneath where it says no hostile contact with victim, okay?
Así que puede prohibir contacto hostil con la víctima, y yo escribí ya el nombre de la víctima, Carmen Cordero, lo escribí ahí debajo de la orden. Eso fue todo lo que hice. No puede tener hostilidad, contacto con hostilidad con esa víctima.
And then no access to any knives where you reside.
Y no puede tener acceso a cuchillos en el lugar donde usted resida.
You must report to the County Credit for Time Served.
Se le da crédito por el tiempo ya cumplido en la cárcel.
Is currently 511 days.
511 days.
511 días.
Court costs
Costa judicial.
will be paid through the clerk of court and
Se
all
pagará
your
las-
fees. How much is the court cost?
La Secretaría del Tribunal.
Court costs of $415, a teen court fee of $3, a battery surcharge fee of $201, and cost of prosecution is $100, totaling to $719.
Entonces va a ser los costos que tiene que pagar, que son los 415 de costa judicial, los $3 para la corte de adolescente, los $201 de sobrecargo por cargo de agresión, los $100 de procesamiento judicial, dando un total de $719.
You are to report, you are to make your first payment 90 days from today at $50 a month.
Entonces, a partir del día de hoy, tiene un plazo de 90 días para comenzar a hacer los pagos. Los pagos serán por cuotas de $50 mensuales.
Judge, may I be heard?
Yes, sorry.
¿Puede decir algo, juez?
The condition that says no weapons or drugs, it also includes no alcohol. That's that word written there in the.
Oh, okay, I apologize. I'm gonna make that a little bit more clear. No worries.
Condición: no se le permite armas ni droga, y se especifica que tampoco alcohol. Ya lo van a escribir ahí.
Okay, there is an additional requirement, Mr. Maldonado.
Requisito adicional:
No alcohol consumption as well.
se le prohíbe el consumo de alcohol también.
Okay, do you understand?
¿Usted entiende? Yes, correct.
Okay. You have to report to the Osceola probation within 24 hours, 24 hours from your release.
Y tiene que presentarse al régimen de prueba, la delegación, perdón, de régimen de prueba del condado a las 24 horas después de su liberación.
Now, do you understand that? Yes or no?
¿Entiende lo que le dije, sí o no?
Yes? Okay. And you will be able to pay your $50 a month?
¿Y va a poder pagar esos $50 al mes?
Sí, correcto.
Yes, correct.
All right, anything further from the state?
¿Algo más fiscal?
Anything further from the defense?
¿Defensa? No, su señoría.
All right, we have a score sheet that was given to me. I have a restitution and DNA order as well, and I have your plea. Mr. Maldonado,
Señor Maldonado.
you have the right to appeal this judgment and the sentence of this court today.
Usted tiene derecho de apelación, tanto de la sentencia como la pena que se ha impuesto.
Any notice of appeal must be in writing and must be filed within 30 days of today's date.
Si usted acaso va a apelar a la pena o a esta sentencia, tiene un plazo de 30 días para solicitar tal apelación si la va a hacer.
If you cannot afford an attorney for purposes of an appeal, one would be appointed to you, okay?
Y si acaso usted fuera a apelar, no podría contratar un abogado le sería designado a usted para propósitos de la apelación.
Good luck, sir.
Buena suerte para usted, señor. Okay, thank you.
Thank you. Next case?
May I be excused, Your Honor?
Yes, thank you, Mr. Santiago, Attorney Santiago. You have a great rest of your day.
Likewise, Your Honor. Thank you.
Does the next case require the service of the interpreter, Your Honor?
No, thank you very much for your time as always.
You're very welcome, Your Honor.
All right. Maldonado, you know how I like to get everything perfect, so let's, yes, we have the plea, we have the criminal score sheet. I have the restitution order, everything has been signed, and that's ready to you. Need to throw away, no black pens. All right, let's see where we are. We are now on page 3 of the docket, and we are at,
Sean Underwood.
and that's 2019 CF 3876 and 2020 CF 2061.
Matt Kazara for the state.
Morning.
Kristen Cronk for Mr. Underwood.
Good morning. And I should have. There we go.
Please raise your right hand, sir. Mr. Underwood? Yeah. Please raise your right hand.
Restitution.
Do you solemnly swear or affirm the testimony you should give to this court is the truth, the whole truth, and nothing but the truth to help you God? It should be there.
Okay. So normally it's the plea form, it's the criminal score sheet, and then guys, even if there is no restitution, the clerk requires a restitution order. So,
I believe there was one included in the score sheet I had sent over this morning, Your Honor.
I don't have that, but I will relook, okay?
Your Honor, it should be at the last page of the score sheet is the.
Oh, yes, I have gotten them earlier, so I was aware of where they are, but I don't have that in this one.
Really? Okay. I'll hand you another one. I've got
No
one.
worries. Thank you. And is that a form that we can have, who gives that restitution form out?
Your Honor, the form prints out automatically at the end of our score sheets.
So sometimes that we don't have them and sometimes we do. What would be that reason?
Well, Judge, anytime we hand you a score sheet, it should have a restitution order unless it's a VOP. If it's just a VOP by itself, it does not need a restitution order because that it goes with the original case.
Right, so if I don't have one, that just means that someone forgot it?
It likely just means that the state forgot it. Yep.
Perfect. All right, guys, let's try to make sure that we do have those. Okay. And sometimes the defense makes sure that.
Well, Judge, it should always be
Thank you so
submitted by
much
the
if you
state.
guys have done that. Okay, no worries, sure. All right, so we are at Sean Underwood. Yes. All right, let's see here. Can we place, Attorney Cronk is your attorney today. And Attorney Cronk is going to place the negotiated plea on the record.
Your Honor, in case 20 CF 2061, the offer is adjudication of guilt, 9 months in the Osceola County Jail with credit for time served, followed by 2 years of level 2 community control, public defender fee and PD lien and court costs, and this will run concurrent with 19 CF 3876.
Okay. State, Attorney Kazera, is that what you have as well?
That is correct, Your Honor. I'll note two things just before we get started. The first is that this is a downward departure offer in exchange for a legitimate uncoerced plea bargain. The second is that Mr. Underwood, in his 2019 case, we're going to be revoking and terminating the terms of his community control, and as a result, and placing him back on community supervision. As a result, we're going to need to do a brief danger hearing at the end of this. He is a violent felony offender of special concern.
Attorney Croft?
Yes, Your Honor, that's all correct.
So I am going, it's a global plea, but I'm going to take them separate.
Okay.
All right. So I'm going to start off with the violation of 2019 CF 3876. Mr. Underwood, can you state your name for me today?
Sean E. Underwood, 42169.
Thank you very much. Now, your lawyer tells me that your wish to change your denial of your violation and admit that you violated the condition of your probation number, can I get that, please? Give me 1 minute, I apologize. Thank you. And that you violated your condition number 5 of the order of probation by failing to live without violating any law by committing the criminal offense of Osceola, failing to report DL for renewal of residence on 9/22/20 in Marion County. Do you understand your charge today?
Yes.
Your violation today?
Yes.
Do you understand that your community control for the following charge of count 1 and count 2, I can't, give me a minute. So do you admit that you violated condition number 5, which was what I just read today, by being arrested? Okay. Are you under the influence of drugs, medication, or alcohol today, Mr. Underwood? Are you suffering from any mental illness or emotional disturbance today? Have you ever been treated for any of those in the past, Mr. Underwood? How far did you go in school? How far did you go in school? And do you read and write English? Did you read and understand the constitutional rights on the form? Did you review this form with your attorney, Croft? And did she answer any questions you may have had? Do you you are now giving up the right to remain silent as to new violations, but can be compelled to testify as to the technical violations? You are giving up your right to be presumed innocent until the state proves by preponderance of the evidence that you are substantially and willfully violated in violation of your probation. You're giving up the right to have a hearing before a judge and to have the lawyer represent you at that hearing. Lawyers can cross-examine state witnesses, call witnesses on your behalf, and present evidence on your behalf. Do you understand that you're giving up all these rights today by entering this plea? All right. Do you understand the maximum punishment for this offense is 10 years in a state prison? Are these your initials on the plea form? At the bottom? On these 2 pages? And what are your initials? Thank you. And is it your signature on the second page? Are you entering this plea freely and voluntarily today? Has anybody forced, threatened, or coerced you to enter this plea? Are you satisfied with your lawyer's representation in the matter today? Great, she's worked hard for you on your case. Do you understand by entering this plea that there will be no trial and I will impose a sentence based upon this plea? And you have a global plea with another case. Do you understand that if you're not a citizen of the United States, entry of this plea will result in deportation? Are you aware of any existence of DNA evidence that would exonerate you? State?
Your Honor, the state's not aware of any.
Defense?
Yes, Your Honor.
Facts? Yeah. Okay, factual basis?
Your Honor, the factual basis for the violation of probation is the same as the factual basis for the new law. I'm happy to put them on the record in both cases or in just one, wherever you like. Your Honor, on December 12th of 1990, the defendant was convicted of a qualifying offense in New Jersey and is required to register as a sexual offender. On June 25th of 2020, the defendant was convicted of 2 counts of failure to register in Osceola County and was sentenced to community control. Later that year, on July 21st of 2020, law enforcement conducted a residence check on the defendant at the Saralago Hotel. Front desk advised the defendant checked in on July 13th to room 175 with his mother and fiance. The defendant updated his address with the sheriff's office, but did not obtain a new driver's license with the new address, as he was required to do by the statute. These events occurred in Osceola County, Florida.
Thank you. All right. Mr. Underwood, today I'm going to go ahead and accept your plea. I find that you are alert and intelligent and that your plea is freely and voluntarily entered, and that you understand the nature and charges, and you have been represented by competent counsel, which you already told me you were satisfied with. I find that there's a factual basis for acceptance of this plea. Is there any legal cause why sentence should now not be imposed?
Yes, Your Honor. Before sentence can be imposed in this case, we will need to do a danger hearing.
Thank you. Attorney Crop? Danger hearing?
Your Honor, the defense has nothing that would determine that Mr. Underwood is a danger. I would defer to the state at this time, and then if they have anything, would respond at that time.
Judge, I think someone's mic might be under.
Yeah, Mr. Kelly, Attorney Kelly, can you place your microphone for me on mute?
Yes, ma'am.
Thank you very much. State?
Yes, Your Honor. So danger hearings, Judge, are governed by Florida Statute 948.06. They list a number of factors that the court should consider. At this time, the state is not arguing that Mr. Underwood is a danger. I would ask the court to take judicial notice both of the criminal punishment score sheet that has been previously provided to the court, as well as the arrest affidavits in both his 2019 and 2020 case, laying out the factual basis for those.
Can I have all those three in front of me?
I believe so, Judge.
I do.
Okay, perfect. Your Honor, the factors that the court is to consider, I'll address A and B at the same time. That's the nature and circumstances of the violation and any new offenses charged. And then B is the offender's present conduct, including criminal convictions. Your Honor, the 2019 case, the violation of probation case, involved an unregistered Text Now account. The 2020 case involved, as we just discussed, a new residence that he had reported to the sheriff's office, but had not reported on his, and had not received a new driver's license for it. The state will note that while both of them are important, neither of them is a violent offense, and neither of them, we believe, poses a substantial danger to the community. The third factor that the court should consider is the offender's amenability to non-incarcerative sanctions based on his history and his conduct during this period of supervision and others. Your Honor, I don't have complete records for all of his out-of-county convictions, but he appears to have successfully completed probation on a couple of prior cases. And as a result, it appears that he is amenable to community sanction. On the other hand, I will note that these are his fourth and fifth failure to register cases, respectively, and I think that weighs against him. The next thing that the court should consider is the weight of the evidence against the offender. Obviously, he is entering an admission today, so I think the weight of the evidence is about as strong as it will ever be. And then the last is any other facts that the court considers relevant. Your Honor, he scores substantial prison time, as you can see from the score sheet. I think he scores 123 months in the Department of Corrections based on this. However, based on the nature of the allegations in both of these cases, the state felt that a short period of jail time followed by a more lengthy period of community supervision would be appropriate. I don't believe that he presently poses a substantial danger to the community. Thank you, Judge. That's all I have pending any questions.
You. Defense?
Your Honor, I would just follow up with what the state said. Has seemed to have done successfully on his community control and probation, with the exception of the failure to register, which I do believe he was still checking in with the Osceola County Sheriff's Office, checking in with FDLE and updating them on everything. It was just an issue of getting the driver's license updated. Other than the underlying and the failure to register, just looking at the history that I have been provided for him, it doesn't look like he's had any violent prior history, just some misdemeanors such as loitering and criminal traffic cases. And that's all the defense has at this time.
Thank you. Based on the success of the community control and probation, although, and coupled with the fact of the affidavits, I will note also that this is the fourth and fifth failure, but I don't find, based on the statute and based on the enumerated terms, that he is a danger to society. I do find in this danger hearing that he has successfully completed community control and probation and thus is not a danger to society at this time and the community. Okay.
Thank you, Your Honor.
Is there anything else now that I can legally impose sentencing for?
No, Your Honor, nothing further that the court needs to do before imposing sentence. Thank you.
Thank you. I'm probably going to ask you to put the same thing on the record twice, though, Attorney Kazir.
That's fine. That's fine. We don't have to do a danger hearing for the other one because it's a new law violation, but I'm happy to say whatever you need me to say.
All right, I'm going to go ahead and adjudicate you guilty with your admittance, and it looks like you're going to be on community control for the new term of 24, level 2 community control. I apologize. And how long is that? A $50 fee, any outstanding court costs, and this is to run concurrent with 20 CF 2061. I don't have admittance. I don't know what this is. RNTPRE.
Revoke and terminate, Your Honor. I apologize.
Say it again.
It's revoke and terminate his prior community control.
Thank you.
And then reinstate with the new 2-year term, level 2. Everything will run concurrent with the 20 CF. Where's the case number?
20 CF
2061 case.
Yes. So just for the record, I wrote on here where you put R&T, I just wrote revoke and terminate, just as someone was looking at. They probably would maybe know the acronym, but if not, I put revoke and terminate the community control. Anything else?
Yes, Judge. So that's
But this one, I'm going to do the next.
right. So just to clarify the record on this one, that is revoke and terminate his current period of community control, sentenced to an adjudication of guilt, 9 months in the county jail with credit for the time that he has served, followed by a new term of 2 years of level 2 community control.
Okay, so that term of 24, it's 24 months.
That's correct. 24 months.
Got it. Okay. I also have here $50 public defender fee, any
And court costs.
which are,
He currently has cost of prosecution of $100, the public defender lien of $100, and he has a current balance of $773.77.
okay. Mr. Underwood, at the end with your next case, I'm going to ask you if you can make that payment in 90 days with $50 a month. Do you think you'll be able to do that?
Yeah, perfect.
Thank you very much. Okay, we're going to go ahead and call up your next case.
Credit time served.
Credit time served is,
For this case, it's
one moment, for your VOP case, your credit time served
is 278 days.
278 days. For your violation of probation case, you have served 278 days, or you've gotten credit for 278 days. I'm gonna now go to your next case, which is a global plea, and in that case, which is 2020 CF 2061, Do you have any questions before I move to that case? Mr. Underwood?
No, you just got me confused. It's the two cases, so the 9 months, so what I have, I'm confused.
So the two cases that we just did, one was for your violation of probation. The one that we just did, you admitted that you violated your probation, I don't have that. You admitted you violated your probation on count 5 by failing to live without violating any law by committing the criminal offense. So what I did today was did your violation of probation. Now your new charge, which is in the 2020 CF 2061 case, I'm gonna go ahead and do the same thing we just did. Acknowledge that you read the plea, and we can go from there. And then when we make your sentences, both of these, when I sentence you, both of them will be the same. We're just individually doing each plea. Mr. Underwood, do you understand that? Okay. So now we are going to move on from your violation of probation and admittance of your violation, which we just did. And now we're going to move on to 2020 CF 2061. It's your same attorney who has done this global plea for you, Attorney Kronk, okay? Same thing. Can you tell me your name and your date of birth?
Sean E. Underwood, 4/21/69.
All right, Mr. Underwood, your lawyer tells me that you wish to change your entered plea of not guilty into a plea of no contest to the following. Failure to report to the driver's license for renewal after change in residence. This is a third-degree felony with a maximum sentence of 5 years in jail.
Yes.
Is that what you wish to do today?
Yes.
Are you under any influence of drugs, medications, or alcohol?
No.
Are you suffering from any mental illness or emotional disturbance?
No.
How far did you go in school?
11th.
Do you read and write English?
Yes.
There was a plea form. This form was 4 pages. Did you initial those 4 pages? What's your initials?
You.
And did you sign the last page?
Yes.
Do you understand that did you understand the constitutional rights on this form?
Yes, ma'am.
Did you review this plea form with your lawyer?
Yes.
Did she answer any questions you may have had? Do you understand the maximum penalty of this offense is 5 years in DOC with $5,000 plus court costs, fees, cost of investigation, and any restitution?
Yes.
Are you entering this plea freely and voluntarily?
Yes.
Has anybody forced you or threatened you today, Mr. Underwood, into making this plea? Are you satisfied with the representation of your lawyer?
Very much, yes.
Do you understand by entering this plea, there will be no trial and I will impose a sentence based upon this plea?
Yes.
Do you understand if you're not a citizen of the United States of America, entry of this plea will result in deportation?
Yes.
Do you understand if you're pleading to sexually violent offense or sexually motivated offense, or if you've been previously convicted of such an offense, entry of this plea may subject you to involuntary civil commitment as a sexually violent offender upon completion of your sentence? Are you aware of any DNA evidence that would exonerate you?
No.
State,
No, Your Honor.
defense,
No, Your Honor.
driving license,
No, Your Honor.
facts.
Your Honor, the facts in this case are the same as the facts underlying the violation of probation in the 2019 case we just addressed. However, on December 12th of 1990, the defendant was convicted of a qualifying offense in New Jersey and is required to register as a sexual offender. On June 25th of 2020, the defendant was convicted of 2 counts of failure to register in Osceola County and was sentenced to community control. On July 21st of 2020, law enforcement conducted a residence check on the defendant at the Saralago Hotel. The defendant had updated his address to the Saralago with the sheriff's office, but had not obtained a new driver's license with the new address within the 48 hours required by the statute. These events occurred in Osceola County, Florida.
Thank you very much. All right. All right, Mr. Underwood, I'm going to go ahead and accept your plea. I find that you are alert and intelligent and that your plea is freely and voluntarily entered, that you understand the nature of your charges and are represented by competent counsel whom you told me earlier that you were satisfied with. I find that there's a factual basis for acceptance of this plea. Is there any legal cause today why we shouldn't end sentence?
Nothing from the defense, Your Honor.
Nothing from the state, Judge.
All right, Mr. Underwood, is there anything you would like to say before I impose sentence today?
Yes.
Is there anything you would like to say before I impose sentence today? Okay, I'm going to go ahead and adjudicate you guilty. And let's sentence you to the following. 9 months of community control, I'm sorry, 9 months of Osceola County Jail with credit time served,
For this case is 143 days.
143 days. You're gonna do 2 years or 24 months on level 2 community control. There's a private public defender fee, public defender lien, and court costs. This is to run concurrent with your 2019 CF 3876 case. Remember we talked about that? So both of these cases are gonna run together, concurrent with each other, okay?
So what was, how much days it was?
So you are sentenced to 9 months in the Osceola County Jail with credit time served of
143 days.
143 days.
Okay, yeah. That's about right, yeah, that's what I got.
All right? And then you will be required to go 2 years to level 2 community control. You have the following fees of a public defender fee, a public defender lien and court cost of
Court cost is $415, a teen court fee of $3, cost of prosecution is $100, and a public defender lien of $100.
for a total of
$680.
$618. I told you that this was gonna run concurrent with your 19 CF 3876 case. So that means when you report to probation within a 24-hour period, after your 9 months, you will then start after 90 days of paying $50 a month through the clerk of court. Do you think you can pay $50 a month towards your obligation?
Yes, yes.
Anything further from the state?
No, Your Honor.
Defense?
Nothing from the defense, Your Honor.
All right, Mr. Underwood, most importantly, you have a right to appeal the judgment and sentence of this court. Any notice of appeal must be in writing and must be filed within 30 days of today's date. If you cannot afford an attorney for purposes of appeal, one will be appointed to you. Any other further questions for me, Mr. Underwood? Good luck, sir.
Question from the clerk. This is a downward departure.
This is a downward departure. I'm gonna write that right here. I'm just gonna write that right on there. There you go.
Your Honor, just for the court's awareness, on the last page of the score sheet, there should be a series of check boxes for downward departure. I believe I checked it already on this one, indicating that it is based on a legitimate uncoerced plea bargain. But if I did not, then I just want to make that clear on the
I
record.
do see that, and some score sheets are different. So some score sheets, the reasons for departure and mitigating circumstances are on another page at the,
They should always be on the last page if the defendant's score sheet ends up in 44 points or more. If it ends up in fewer than 44 points, then it won't print that out at the end.
got it. All right. All right, everything for Mr. Underwood is right here. Thank you. Next case?
Next case is Hunter Weber, case number 2018 CF 2570, case number 2019 CF 59, and 2019 CF 4319.
Mr. Mayor, on behalf of Mr. Hunter Weber on case number CF 19-59.
Rose Rosas on behalf of Mr. Hunter Weber on case number 18 CF 2570 and 19 CF 4319.
Maria Morales on behalf of the Commissioner.
Perfect.
Mr. Weber, please raise your right hand. Do you solemnly swear or affirm the testimony you should give to this court is the truth, the whole truth, and nothing but the truth, so help you God?
Sometimes the restitution order has name and address of the victims. And then at the bottom, this is the very first time I've seen name and address of the victim with the victim's information and their address to be confidential. Should that always be there?
That the name and address are confidential? No, Your Honor.
It's only when it's requested?
Only when it's requested. That's based on Marcy's law, Your Honor. And there are some elements of Marcy's law that are self-executing, but the requirement to keep their address confidential is one that the victim has to request.
I'm sorry. It says, unless otherwise requested by the victim or person representative of the victim, the DOC will notify the victim or person representative of the victim within 6 months before the inmate's release. That's what I'm talking about. And then you have the name and address there for that person to be notified 6 months prior. This is the first time I've seen that.
Can I see, Judge?
This is perfect. This paperwork is obviously great. Everything is intact but I just like uniformity. So if it's supposed to be done. Yes, that language is, but the name and address is normally not filled out. For example, can you give me the last restitution order that we just had? Perfect example, if, this one, not this one, the one that has a name on it. So let's look at another one.
We have an restitution order.
Let's see, we just took Somers, would be a perfect example. SOMERS.
I don't know if Somers had it. Somers pled to a misdemeanor, but Mr. Irizarry.
Yeah, someone didn't. So all I'm saying is that I'm noticing, no big deal. But
Sure.
Yeah, no big deal. No big deal.
Same as you do, that we're doing it right in each case.
Yeah.
Mr. Underwood doesn't have anything because there's no.
Correct, so I'm not, it's the Somers case and then the Irizarry. So we can look at
Somers,
those two.
there's no order because she ended up pleading to a misdemeanor, so you won't find one of those. But on Mr. Rodriguez, sorry, I believe there were restitution orders, Your Honor.
And in that section, there was nothing there. In the section for the name and address for that person to be made aware in the 6 month period of time. So if we can just make sure that those are completely filled out on the restitution orders.
Yep, in the order for 3002, there is no victim because that's a possession of controlled substance case.
Yeah, and some of them I'm not. I'm just making a notes of the ones I do know for a fact that there was restitution on, and I don't see it. This is a perfect example. This is not. It says restitution is not applicable, so it'll be another one. But we don't want to waste the time.
Yeah,
but right there, it should always be this. This paperwork is absolutely perfect.
Okay.
And I would like this every time.
All right, Your Honor, I will.
If applicable.
Right, I will work with the clerk while you're addressing this case, and we'll make sure that the ones that were done today were done.
Perfect. Thank you so much. And no big deal. I just what I've been noticing.
No, I have no problem with the court taking the moment to making sure we understand everything and everything is fair.
Just want to make sure that if there are victims, that they are being protected, and if I can help that, that's great. And thank you so much for everything being nice and organized and ready. Okay, so Mr. Weber, how are you doing today?
Say again?
Is your name Mr. Is your name Hunter Matthew Weber?
Yes, ma'am.
Okay. So Mr. Weber, your attorneys are here with you today. And so it's the state, and they can see you. And we are going to first do 2018 CF 2570, which is admission of violation of probation. This is a global.
No, actually, they're being treated separately or being set separately. My case is going to be a time served offer.
All right, so let's do them separately. All right, 2018 CF 2570, we'll call that first. And Mr. Weber, can you please put your right hand up?
He's been sworn in, Judge.
You have? Great. All right, Mr. Weber, you are now going to withdraw your plea of not guilty and admit the violations as alleged, which are, can I get the information sheet? Every time. Thank you. Violation of special condition impulse control class of the order of probation by failing to successfully complete an impulse control class and be responsible for the payment of any costs incurred while receiving said treatment, unless waived. And now, do you understand and admit to the violation of the special condition?
Yes, ma'am.
All right. You are giving up the following. One, you're giving up today, Mr. Weber, your right to remain silent as to new law violations, but can be compelled to testify as to technical violations. You're giving up your right to be presumed innocent until the state proves by preponderance of the evidence that you substantially and willfully violated your probation. You're giving up the right to have a hearing before a judge, to have a lawyer represent you at that hearing. Lawyers can cross-examine state witnesses, they can call witnesses on your behalf, and present evidence on your behalf. Do you understand today, Mr. Weber, that you are giving up all those rights by entering this plea?
Yes, ma'am.
And you did admit to the violation of your probation?
Yes, ma'am.
All right. Are you under any influence of medication, drugs, or alcohol today?
No, ma'am.
Are you suffering from any mental illness or emotional disturbance?
No, ma'am.
Mr. Weber, have you ever been treated for any of those in the past?
I did go to the state hospital.
Yes, Your Honor. He was previously found incompetent in this case, but he regained his competency well before today.
Thank you.
And I might add, I'll bring it up now because this is a joint plea, but Mr. Weber does take mood stabilizing drugs.
Yes.
But he's indicated that he's not affected by them adversely, so it does help him think rationally.
Thank you. Is that your understanding, Mr. Weber?
Yes, ma'am.
Okay. How far did you go in school?
I got an associate's in science.
Okay, okay, thank you. Do you read and write English?
Yes, ma'am.
Do you and you don't need an interpreter today?
No, I do not.
Did you read and understand the constitutional rights on that plea form?
Yes,
And I'm
ma'am.
gonna show it to you. All right, and what is your initials?
HW.
And did you sign the back of this plea form?
Yes, ma'am.
Do you understand that the maximum penalties for you today are 5 years in state prison
Yes, ma'am.
to the charge of robbery, setting, snatching? Are you entering this plea freely and voluntarily?
Yes, ma'am.
Has anybody forced or threatened you?
No, ma'am.
Has anybody promised you anything other than what your lawyer has placed on the record?
No, ma'am.
Are you satisfied with your lawyer's representation in this matter?
Yes, ma'am.
You've had 2 great lawyers. Do you understand by entering this plea there will be no trial and I'll impose a sentence today?
Yes, ma'am.
Do you understand if you're not a citizen of the United States, entry of this plea will result in deportation?
Yes, ma'am.
This is sexual. Okay. Are you aware of any DNA evidence that would exonerate you?
No, ma'am.
State?
No, Your Honor.
Defense?
No, Your Honor.
Factual basis? 2018 CF 2570, since it's not a global.
It is a global.
Well, I mean, there's one score sheet, so it's not going to change the offer. I'm getting time served on my case.
Okay.
And then, right, and then it's time served on this VOP case, and then he's going to go on probation on his 3rd case.
Got it.
So,
I have, well, I'll do it after you give the factual basis.
Sure. So for 18 CF 2570, it's a violation of probation. Let me just find the condition that he's alleged to have violated. Hold on.
Impulse.
Yes, it was the technical violations for the impulse control, and then presumably there would also be one for the new cases. Hold on. Okay, so for the impulse control, there's no special condition number. It's just the impulse control.
Yes.
And then the other ones are violations of condition 9, which is complying with instructions.
And there's an amended violation. Well, I mean, I'm going to say that in my, but there is also an
And
amended.
then condition 3 for changing the residence. Condition 4 for possessing or carrying a weapon. The basis for that one will be in 19 CF 59. And then condition 5, which is failing to live without violating any law, and committing, criminal offenses.
Thank you. Mr. Weber,
Yes, ma'am.
are you admitting, you've admitted to the violation of special condition and post control costs. Are you admitting to the violation of number 9 of your order by failing to comply with all instructions given to you by the probation officer?
Yes, ma'am.
Are you admitting to violation of condition number 3 by changing your resident without procuring the consent of the probation officer?
Yes, ma'am.
Are you admitting to violation of condition number 5 by failing to live without violating any law by committing the criminal offense of burglary to a structure and conveyance while armed or lesser included offense on January 6th?
Yes, ma'am.
Are you admitting to the violation of condition of number 5 by failing to live without violating any laws and being arrested for the criminal offense of petty theft first offense?
Yes, ma'am.
And also the same violation for aggravated assault with deadly weapon and without the intent to kill?
Yes, ma'am.
Same violation, number 5, battery, touch, or strike.
Yes, ma'am.
Violation of condition number 5 again by committing theft, resisting recovery, recovery or property, pardon me.
Yes, ma'am.
Violation of 5 is again as far as being arrested for the offense of escape or lesser included on 12/22/2019.
Yes, ma'am.
Violation of condition number 5 by failing to live without violating any laws, and that would be resisting arrest without violence on 12/22 in Osceola.
Yes, ma'am.
And that resisting arrest without violence, 1, 2, 3, 4. All right. And then resisting violation of condition 5, pardon me, the criminal offense of false name or ID by an arrestee.
Yes, ma'am.
Violation of condition 5, a burglary 20 cc dwelling unarmed.
Yes, ma'am.
Thank you. I'm going to go ahead and the prosecutor and has agreed to credit adjudication of guilt, credit time served, VOP case,
Is 495 days.
495 days, revoke and termination of your probation court costs, and this is going to run concurrent with your 2 other cases, okay? So you're going to hear me say this again twice. 2019 CF 319, 2019 CF 59. Okay?
Yes, ma'am.
So anything further from the state and defense on this case number? I'm going to go to the next one in a moment.
Your Honor.
No, Your Honor. I thought he had more credit time served. But, all right.
For this case, I'm showing 495 days.
Yes, 400, Madam Clerk has 495 days.
On 18 CF 2570?
Yes.
Okay.
Defense?
Oh, no, there's nothing further from defense.
Then this is a time served, Judge?
The credit for time served on this case, he has credit for time served on this case. Was that correct?
Yes.
2018. Now we're going to go on to the next 2 cases.
Right, okay.
On the same page?
I'm sorry?
On the same page?
Yes.
You have the right to appeal the judgment and sentence of this court. Any notice of appeal must be in writing and must be filed within 30 days of today's date. If you cannot afford an attorney for appeal, one will be appointed to you. Mr. Weber, can you please stay right there as we're going to go over the plea form of your next 2, and I will do these together. And this is for CF 1959 and CF 4319. Can we get the negotiated pleas for both of those?
On CF 19-59, this will be a time-served sentence. Mr. Weber understands that he has 553 days credit as of today's date. That includes the time spent at the state hospital while he was incompetent. I might also add, on behalf of Mr. Rosas and myself, Mr. Weber understands, or he should understand, I discussed it with him, that he has the right to a PSI. PSI stands for pre-sentence investigation.
Yes.
Because he was not convicted of the first felony, so technically he's conviction-free, although the withhold became a conviction with the VOP. But the bottom line, Mr. Weber's entitled to a PSI. He will waive his right to a PSI and be sentenced, however.
Mr. Weber, did you hear your attorney?
Yes, I did.
And are you waiving your right to the PSI?
Yes, ma'am.
Thank you. All right, so Mr. Weber, I'm gonna,
Your Honor, did you want to hear the resolution for the other case now?
yes,
Okay,
I'm gonna do
so-
those together.
As to 19 CF 4319, the state is going to null pros counts 3, 4, and 6. As to count 1, it would be an adjudication of guilt, credit time served, followed by 12 months of probation, with the conditions being a mental health evaluation and any recommended treatment, and random urinalysis and court costs. And as to count 2, it would be an adjudication of guilt, credit time served. As to count 5, adjudication of guilt, credit time served. Count 7, adjudication of guilt, credit time served. And count 8, adjudication of guilt, credit time served.
Perfect, thank you.
Thank you.
Great. All right. Your lawyer tells me that you, Mr. Weber?
Yes, ma'am.
Your lawyer tells me that you wish to change your previously entered plea of not guilty and enter a plea of no contest today on the following. On CF 1959, that is for count 1. Give me 1 minute. Can I get the information, please?
It's armed at trespass, charged with a weapon.
Yes, no worries. Just give me 1 minute. Thank you. Thank you. Oh, yes. Armed trespass in a structure, and that's a maximum of 5 years. I'm gonna do your, I'm gonna take the plea of 2019 CF 4319, and that is, also, you wish to change your previously entered plea of not guilty and enter a plea of no contest to count 1, aggravated assault with deadly weapon, count 2, petty theft misdemeanor, count 3, battery, count 4.
Your Honor.
Pardon me, some of these are not, no cost, right?
Yes, well, they will be. But
So I'm just gonna say that now, and then in the end, when I give the sentencing, I will say which ones were.
I think it's clear for the record if we just, you just sentence him on the cases that he's pleading to, and then the state will null pros the remaining counts that have not been addressed.
All right, count 1, aggravated assault with deadly weapon. Count 2, petty theft. Count 5, resisting officer without violence. Count 7, providing false identification to law enforcement officer, a first degree misdemeanor. And count 8, trespass of property other than a structure or conveyance. Is that what you wish to do today?
Yes, ma'am.
All right. You've indicated, are you under any influence of drugs, medication, or alcohol?
No, ma'am.
Are you suffering any mental illness or emotional disturbance?
No, ma'am.
Have you been treated for any of those in the past?
I did what the state asked me.
And how far did you go in school?
2 years in college.
Did you read and write English?
Yes, ma'am.
All right, now there's 2 plea forms that I'm showing you here. The 4 pages, is that your initials?
Yes, ma'am.
And there's another one. And is that your signature on page 4?
Yes, ma'am.
And what are your initials?
HW.
And do you think that this plea is in your best interest?
Yes, ma'am.
Do you understand that the maximum penalties for the crime are 5 years prison, 3 years, plus 3 years, and 60 days of county jail, or 8.5 years of probation with a total max fine of $8,500 plus court costs, fees, court's cost of investigation and restitution?
Yes, ma'am.
Are you entering this plea freely and voluntarily?
Yes, ma'am.
Has anyone promised you anything other than what your 2 lawyers today have placed on the record?
No, ma'am.
Are you satisfied with your lawyer's representation of you in this matter?
Yes, ma'am.
You should be. She's a great lawyer. Do you understand by entering this plea, there will be no trial and I will impose sentence upon you based on this plea?
Yes, ma'am.
Do you understand if you're not a citizen of the United States, entry of this plea will result in deportation?
Yes, ma'am.
Facts?
Yes, Your Honor.
I'm so sorry. Is there any DNA evidence that would exonerate you? Do you believe? State?
No, Your Honor.
Defense?
No, Your Honor.
Facts?
Your Honor, may I ask for clarification before we continue with this?
Sure.
I was, the offer that was conveyed, that what I'm agreeing to, it was based on the representation that the defendant had on 18 CF 2570, at the time, about 698 days of credit time served. But today, it was clarified by Madam Clerk that he's got
400 VOP.
495 days of total credit time served. I need to understand the discrepancy there. And then I'm assuming the same is going to happen on 19 CF 59, where it was represented 604 days, but it looks like we're at 553. That one I'm not actually too concerned about because it's pretty close.
Attorney Morales, do we have a plea?
Your Honor, just to clarify for the state, we didn't intend to misrepresent his credit time served. That was something that we did calculate on our own, and we were pretty confident that that was accurate. So just for the state's information.
And on 1959, I never said it was 605 days. I always said it was 553 in accordance with what the clerk is saying.
So Attorney Smear is saying that he gave you the recommendation of the clerk as well. So they're not sure where that other number may have come from.
And I'm thinking with the VOP case, it might be that he might have had credit from maybe before he pled or maybe from, I'm not sure, but.
Just to make sure that it's correct.
Okay, so Madam Clerk, this part I am not, I wish I could jump in. I'm really good at order, but this part unfortunately is an issue with the clerk's department and their role. So we're just going to clarify that. Now, my question is, because we just went through this plea. So if that is not accurate, are you now withdrawing your plea, or is there a change that you would like to talk to the defense about? And we can do that.
I mean, because the whole purpose of this was that he was close enough to basically get credit time. So his sentence would otherwise be Department of Corrections. But when his credit time served is believed to be, it would be, I think the total would be like 720 days. If he's in the high 620 days, there's no sense in making him wait to get processed by DOC and potentially be in custody longer than needed. But if we're talking about a couple hundred days, that absolutely changes it, and then it wouldn't just be 19 CF 4319 when he would be under supervision. The only reason supervision was on only that case is because that case was supposedly way off in the credit time served than the other two cases.
Definitely, and this is not me getting into any type of plea negotiations with you guys at all. So for at that moment and at this matter, maybe we reset this plea because it doesn't sound like everyone is on the same page. Mr. Weber? It's okay. I'd much rather get it right. However, I can say that the defense, for record, was ready to go in all of their forms.
Judge, I apologize on behalf of the clerk's office. There was a error in the credit time served. He actually has a total of 746 days.
Did you hear that? There was an error and the actual time credit served is?
746 days.
746 days. Does that help out with your continuation of this plea?
Is that for for 18, for the VOP case?
Yes.
Yes, so in that case, right, it should be, okay, yes. So then that means that on 19 CF 59 and 4319, it'll also end up being a little bit higher than what you guys had estimated.
Can you give I would like to put on the record every single credit time served for every case, okay? Let's just do that so we're all on the same page. All right, so for 2000 and, I just took that and gave that to you. So for the VOP case, which is 2018 CF 2570, Madam Clerk, can you please put the amount of credit time served on the record?
The amount of credit time served for 18 CF 2570 is 746 days.
746 days. Defense heard?
Yes, Your Honor, that sounds more correct.
Thank you. ASA Morales, are you satisfied with that number?
On that particular case so far, I have no objection to the violation of probation admission proceeding as scheduled.
Perfect. So we've already done the plea colloquy for that one. I'm going to move on to 2019 CF 4319. Can we please give the credit time served for Mr. Weber?
It's 409 days.
409 days. Okay.
Okay, yeah, and we anticipated.
And then CF 1959,
553 days.
553 days.
Okay, that one's a little lower, but I'll put on the record, it's not significant enough to change state's position as to the resolution.
So as of right now, after we have heard all of the credit time serves and have clarification from Madam Clerk, the state has no objection with moving forward with the plea colloquy, with the plea of both CF 1959, 2019 CF 4319. Is that accurate, Attorney Morales?
Yes, Your Honor, and I thank you, and Madam Clerk and Defense for clarifying for me.
No worries. We love clarifications. That ensures that the record is preserved. Okay, Mr. Weber, there was a couple things that just kind of happened. I want to make sure that you understand what just happened, okay? So we wanted to make sure that everybody in this courtroom got the accurate reflection of how many days that you had already served, or your credit for those said days, okay? That number was very indicative of you and your plea offer that you negotiated with your attorney. And so the state attorney just wanted to make sure that she had the same numbers as the clerk when they gave those numbers out. Everything looks like everyone has the same numbers, and we're going to go ahead and proceed now to finalizing your plea, okay? All right. State defense, anything?
No.
No, Your Honor.
State. And now I don't even remember.
Oh, yes, Your Honor, and then you were waiting on me to give facts for.
That's where we were.
Judge, just to go back to the
59, I
BOP,
think.
so that's changing the sentence to,
Give me one moment.
746 days with credit for 746 days, correct?
That is correct. Now, Madam Clerk, just so the record is clear, I've already given the very introduction of the plea colloquy. We are at the section where you are going to be identifying factual findings for us for the case of CF 1959, 19 CF 4319. Facts?
Yes, Your Honor. Okay, as to case number 2019 CF 0059, on or about January 6th of 2019, the defendant was found inside the property located at 14 East Lakeshore Boulevard in Kissimmee. When they made contact with the defendant, he had a jacket wrapped around his hand. Inside of the jacket was a knife. The defendant did not have permission to be in the property. All these events occurred in Osceola County, Florida.
Thank you.
And then as to, give me a second here, I want to make sure I compare the facts to the cases, or to the counts that he is pleading to.
Can you send a message when I come up? Please. My phone number.
All right, on December 14th of 2019, Family Dollar employee observed the victim, the Family Dollar employee who was the victim observed the defendant walking through the store carrying a black gym bag. They approached him, let him know that he had to leave the bag at the front while he shopped. Later on, the victim saw merchandise falling out of the defendant's bag. The defendant ran out of the store and the victim gave chase. They got into a verbal argument, and the victim took out a box cutter to attempt to cut the bag open. When the defendant saw the knife, he tried to grab it from the victim. He actually succeeded and then threatened to use it against the victim. The victim and the defendant later got into a physical altercation. The bystanders helped separate the two. During that altercation, the defendant struck the employee without consent. When law enforcement arrived, they observed the defendant and the victim still arguing inside the store. When they tried to secure the defendant in handcuffs, but he resisted and was able to break free and flee the area. He was not able to be located on that date. A bolo was put out. On December 22nd of 2019, law enforcement were able to locate the defendant and began chasing him. He jumped through fences, ignoring law enforcement commands. The victim, Orlando Delgado, gave consent to law enforcement to search his backyard because he had just observed the defendant jump over his fence and he was possibly still hiding in his yard. Law enforcement Found the defendant, gave chase, and eventually was able to secure him. When he was put into custody, he advised law enforcement that his name was Chris Anthony Brown. Later, when the defendant was fingerprinted, it was confirmed that his name was actually Hunter Weber. All these events occurred in Osceola County, Florida.
Thank you. All right, Mr. Weber, I will accept your plea. I find that you're alert and intelligent. I find that your plea is freely and voluntarily entered, that you understand the nature of your charges and represented by competent counsel whom you've already told me that you were satisfied with. I find that there's a factual basis for acceptance of this plea. Is there any legal cause why sentence should now not be imposed?
Nothing from defense.
No, Your Honor.
All right. Mr. Weber, is there anything that you would like to say before I impose sentence?
I don't have to do any more time on this, right? My plea is my plea. I get the year of probation, right?
I'm gonna go ahead and sentence you right now.
Okay.
All right, I'm gonna go ahead and adjudicate you guilty with credit time served. I'm going to have followed by 1 year supervised probation, mental health evaluation, year analysis, court costs, concurrent to run concurrent with 2019 CF 59 and 2018 CF 2570. On your first charge, second charge is adjudicated guilty, credit time served. On count 5, adjudicated guilty, credit time served. On count 7, adjudicated guilty with credit time served. On count 8, adjudicated guilty with credit time served. As far as your counts 3, 4, and 6, the state has agreed to no process those as part of your negotiation. Do you understand?
What is that last part again?
Count 3, 4, and 6. Those for the charges of.
Your Honor, could I answer the question for him? Mr. Weber, those charges are going to be dropped, the 3 that she just mentioned, 3, 4, and 6.
Oh, okay.
Okay?
All right. Is there, wait, give me 1 minute. There's going to be, you're going to pay your court costs and other costs to the clerk of court. Do you think you can pay $50 a month after I give you 90 days?
Yes, ma'am.
All right. Anything further from the state? Defense?
No, Your Honor.
All right, Mr. Weber, the most important part is you have the right to appeal the judgment and sentence of this court. Any notice of appeal must be in writing and must be filed within 30 days of today's date, okay? If you cannot afford an attorney for the purpose of an appeal, one will be appointed to you. Any further questions for me, Mr. Weber?
No, ma'am.
Good luck, sir.
I'm sorry, excuse me, maybe I got a little bit confused. I heard the court say, Mr. Weber, 1 second. I heard the court say that you were giving Mr. Weber probation concurrent to CF 19-59.
His fees.
On his fees, I'm sorry.
I said his court costs
Okay.
will run concurrent, pardon me, with them all, and then
Yeah.
he'll add 90 days, he'll pay
Yeah.
50, okay.
I missed the court's pronouncement. Thank you.
Don't get it good.
Thank you. Good luck, sir. Court's in recess for lunch. Wait, there's a person. Attorney Kelly? What case do you have with me?
I have Dominic Parente. He's on his 2020 DF 3284, the bond hearing.
Let's go ahead and I'm gonna go ahead and just take that really quick, if that's okay. I know we're pushing. I'm just gonna take that. Is that okay, Attorney Olvera?
Yes, Judge.
Okay, thank you.
This is really simple.
Yeah, I was gonna do it in chambers, honestly, but I just to have a little hearing on it.
That's okay. You got a lot going on.
Yes, I've read the motion. There is no objection from this. Let me call the case. Calling case 2020 CF 003284. Parente Dominic.
Yes.
Hello, Mr. Parente. How are you doing today? Your attorney is here on the line, on the Microsoft team, as well as the state attorney, Olvera. All right, Attorney Kelly, I've read your motion already. I'm going to go ahead and set the bond. There has not been any objection from the state. State, is that still the premise?
Yes, Your Honor, and I also provided the score sheet for Your Honor to review if there's no criminal history, so it just,
I saw it. Thank you very much. And okay. And thank you for writing the lower portion as well of the restitution order. All right, you are requesting, based on your motion, you are just requesting a bail on the original bonds in 20 CF 3284 to be reinstated.
Yes,
And
ma'am.
also the court to set a bond on 20 CF 3357. Has that been filed, the information?
No, sir. No, ma'am, just, some circumstances have changed since I filed that motion. They no info that case.
Oh,
The only
perfect.
case he has pending is this.
All right, we're gonna go ahead and reinstate the original bonds on 20 CF 3284 with any pretrial release conditions that were applicable. Can I see that? 20 CF 3284 original bond? And so I will go ahead and grant that and reinstate the original bonds due to 20 CF 3357 being no pros. I think me reinstating the original bonds are applicable in this case. And the original bonds were as follows. Oh, thank you. The original bonds are count 1, burglary auto of other conveyance, $3,500. Burglary auto of conveyance, $3,500. Petty theft, $750, $250. Petty theft of $750, $250. Their special conditions are the following. Bonds with condition of pretrial release on all that qualify, no contact whatsoever with the victim. What's the victim's name?
There's two victims, Your Honor. The first one is Jennifer, last name I'll spell it out, Canone. And the second
Wait, one moment. Mr. Peretti, do you realize that you are not to have any contact with victim? Can you say her name? Again, I'm sorry.
Jennifer, I'm gonna say Can one.
Miss Jennifer Can one, whatever last name that you are identifying her by, please don't have any contact with that victim. Next victim.
Nather Feliciano.
Nather Alfociano.
Wade Stewart.
And Wade Stewart. Are you aware that you're not to have any contact with those three victims?
Yes.
Thank you. No hostile contact with the victim. No return to the scene of the offense, 1205 Cypress Court, 4401 Pine Lake Drive. Do not possess any weapons or firearms. I'm going to go ahead and do not consume any alcohol or controlled substances. I'm going to add that to this bond. Do not consume any alcohol or controlled substances. Okay, are you aware of those additional pretrial release conditions?
Yeah.
Anything else further, Attorney Kelly, that I can help with?
No, ma'am.
Can you send me an order?
Yes, ma'am.
Thank you very much, State. Anything I can help with?
That's it, Judge.
Thank you very much. Thank you very much, Mr. Peretti. You have a good luck, sir.
It's been a long day, so I think maybe we may have missed something, but I confirm with the clerk, I don't remember you hearing a sentence on CF 19-5 by Mr. Hannah Weber. So I know we sent this in on two of the cases, here's the third case.
I put them together. The 2019, so that's what
That was supposed to be a sentence of simply time served.
that was. Okay. Wait, is Mr. Weber still there? Can you bring him back, officer? All right, let me see it.
I'm gonna get one out.
Thank you.
Just to follow, when you say credit time served, that's the sentence?
Yeah,
Okay.
sorry. Yes, ma'am.
No, okay.
Yes, ma'am. I'm sorry.
You're fine.
So, Attorney Morales, we're back. We're on Hunter Weber. We're on Hunter Weber. What? Everybody come up. All right, Madam Clerk, you stand up too. All right. Here you go. I'm gonna step over. Madam Clerk, stand right here. You stand right here. And you stand right here. Now, you guys identify what are the issues that are left. Which is the issue? This is the one that we've already put on the record with the VOP. We've clarified those time dates at 700 and whatever dates with Attorney Morales. Everybody good on that one? Page turned over. Next one. I've identified every single, at the same time, I did 2019 and I did read those together. So when I did the plea, I was doing CF 1959 and I was doing 19 CF 4319 and I did those together. That's when we talked about Mr. Weber not doing PSI and I put that on the record. What did I not include on the record?
I do recall there's actually been three sections. The intent is simply to get a time served sentence, again, it's 553 days. The next section is on now.
Okay.
I don't think this was mentioned.
All right, so I will go ahead and mention it again, and this one right here for this specific case number on count 1 is adjudication time served, accurate?
Right.
And do you have a credit for time served and numbers?
553.
Let's verify. Thank you.
Yes.
553? Yes. All right.
She's just asking everybody to be there, Mike, so they can pick it up. She's having a hard time picking up what you guys were discussing.
Okay,
Judge,
yes?
can we, while we're waiting for, they send them back to the, wherever, they send them back to the pod? Do you want to continue with the next?
I
one till
don't.
we get 'em?
How long will it take to get Mr. Weber?
Probably like another 5-10 minutes.
All right.
Your Honor, do you want to bring him back after lunch, or, I don't?
Nope, I want to get this one done.
Okay, perfect.
Yep.
I
In the
don't think,
meantime, let's go ahead and see if we can knock out another one. Thank you very much, officer.
we have a volunteer, Your Honor.
All right, we are Matthew Watson, 2019 CF 2542.
Rose Rosas on behalf of Mr. Watson.
Hi, Mr. Watson, how are you doing today? Doing great, thank you. Let's get the credit, we know how many credit, let's go ahead and see the credit time served. All right, you're here today, we're gonna be taking a plea, and your attorney's gonna put negotiations on the record for me today. All right, for Mr. Watson, we have Attorney Rosas, and we have ASA Alvera. Can we go ahead and put the negotiation on the record, please?
Yes, Your Honor. So in this case, Mr. Watson will be entering pleas of no contest as to counts 1 and 2 as charged. The proposed resolution in this case is as to count 1, an adjudication of guilt, 180 days in the Osceola County Jail with credit for 128 days and court costs. And as to count 2, it would be an adjudication of guilt and court costs.
And there is no probationary term, correct?
Yes, Your Honor, that's correct. There's no probation.
There is no probation. How many days do you have credit time served?
94 days.
How many days do you have credit time served?
128. The other Madam Clerk just recalculated it because it was incorrect, so now it's 128 days.
Where did you get that?
There was an out-of-county arrest in this case in Orange County, and I think that benchmark is showing that he was last arrested in November when he was actually arrested in September. So if you open up the out-of-county warrant from Orange County, it'll show that he was arrested on September 29th of 2020, and he also had some credit prior to that.
So I'm gonna just give the clerk, again, I can't, my hands are, my hands are tied. I promise I'm like Superwoman, but in this instance, I'm just She-Ra. No, I'm just kidding. I'm just kidding. That was a bad joke.
I got it.
Mr. Watson, thank you for standing there. We just want to make sure that everything is accurate and reflective, okay?
Correct. Yes, ma'am. Appreciate it.
Of course. Attorney Cazares, this is why I like to take each, by the way, that's why I do each individual one. I'm trying to be cooperative with you guys, but that's why I do one, and then one, and then one.
Absolutely fine, Judge. This is, whatever way is going to keep it straight for you and for the record, that's the way I want it done as
Yeah.
well.
That's why I like to do it one at a, I know it takes a lot more time, but then we would never have this, because I would have done one, and then I would have done one, and then I would have.
I'm showing 129 days, Judge.
You're showing how much?
129.
Okay, so we're showing 129 days. Is that everybody?
Yes, Your Honor, may I just check the plea form to make sure that I wrote that down, because I think I did write down.
There was just no, there was no numbers.
Oh, I didn't write anything.
Yeah, but you can,
Then that's fine.
sorry, just the number of the credit time served again?
I have 129.
Okay, we have 129 days for credit time served. It looks like that has not been objected to or there's any issue, so I'm going to continue with the plea. All right, Mr. Watson, can you tell me your name and date of birth?
Matthew Watson, November 15, 1999.
All right, your lawyer says that you wish to change your previously entered plea of not guilty and enter a plea of no contest to count 1 of grand theft of a motor vehicle and count 2, grand theft third degree. Is that what you would like to do today?
Yes, ma'am.
Are you under any influence of drugs, medications, or alcohol?
No, ma'am.
Are you suffering from any mental illness or emotional disturbance?
No, ma'am.
Have you been treated for any of those in the past, Mr. Watson?
No, ma'am.
All right. How far did you go in school?
Associates in Arts and Business Management.
All right. Did you read and write English?
Yes, ma'am.
Did you read and understand the constitutional rights on this plea form? 4 pages?
Yes, ma'am.
Did you review this form with your lawyer?
Yes, ma'am.
Did she answer any questions you may have had?
Yes, ma'am.
I'm sure she did. How many, out of these 4 pages, what were your initials?
MW.
And did you sign the back of the form?
Yes, ma'am.
Do you understand that entering this plea, you're going to give up each of those constitutional rights listed on this form?
Yes, ma'am.
Do you understand that the maximum possible punishment for this offense is 10 years in prison, $10,000 fine plus court costs, fees, cost of investigation, and restitution?
Yes, ma'am.
Are you entering this plea freely and voluntarily?
Yes, ma'am.
Has anybody forced or threatened you in order to get you to enter this plea?
No, ma'am.
Has anybody promised you anything other than what your lawyer has placed in the record today?
No, ma'am.
Are you satisfied with your lawyer's representation of you on this matter?
Yes, ma'am.
Do you understand by entering this plea, there will be no trial, and I will impose a sentence based upon this plea?
Yes, ma'am.
Do you understand if you're not a citizen of the great United States, entry of this plea will result in deportation?
Yes, ma'am.
Are you aware of any existence of any DNA evidence that would exonerate you?
No, ma'am.
State,
Not from the state.
defense,
No, Your Honor.
okay? Factual basis.
Yes, Judge. On or about March 26th.
You gotta speak up a little bit there, I'm having problems hearing you.
Is this better?
Yep.
Okay. On or about March 26th of 2019, law enforcement responded to 2650 Holiday Trail in Kissimmee, Florida, in reference to a stolen vehicle. Law enforcement met with the victim, who advised that he had been staying with him. And when the victim awoke to leave his residence, he noticed his vehicle was missing out of the driveway. The victim also noticed that the keys and over $2,000 was missing from his wallet. Victim did not give the defendant permission to use his vehicle. Incident occurred in Osceola County.
Thank you. I will go ahead, Mr. Watson, and I will accept your plea. I find that you are alert and intelligent, that your plea is freely and voluntarily entered, and that you understand the nature of the charges and are represented by competent counsel, whom you told me today you were satisfied with. I find that there's a factual basis for acceptance of this plea. Is there any legal cause why sentence should now not be imposed?
No, Your Honor.
All right. Anything from the state before I impose?
Yes. Yes, Your Honor. I did speak with the victim in this case. He wanted to he let us know that he was able to recover the money and the vehicle. There were no damages done to the vehicle, and he was okay with the resolution of this case.
Thank you very much. State, anything from the defense?
No, Your Honor.
Is there anything you would like to tell me or talk to me about, Mr. Watson, before I impose you a sentence?
Yes, ma'am. I have a detainer for Polk County. I was wondering how long you would allow Polk County to come and get me after I'm done with my sentence here.
Okay, your lawyer is going to be able to talk to you in regards to anything else. Do you have anything particular about this plea that you need me to help you with today? Okay. So I'm going to go ahead and adjudicate you guilty. I'm going to find that you have you're going to have 180 days in the Osceola County Jail with credit time served for
129 days.
You're going to have court costs, and those court costs will be paid through the clerk of court. Do you think you'll be able to pay $50 a month, Mr. Watson?
Yes, ma'am.
I'm going to start your first payment towards that obligation in 90 days, okay?
Yes, ma'am.
As far as your second count, you're adjudicated guilty with credit time served. You understand? Okay. And there is no probation. Yes?
It was just an adjudication of guilt and then court costs.
I'm sorry.
Yeah.
CC. I bet. You're right. You guys have to, I know you guys are cool with these acronyms, but let me just write it up for right. Not the easy one, though, I should have thought. For the count two, I'm gonna adjudicate you guilty, and then you'll just be responsible for court costs, which are?
Court cost is $415, a teen court fee of $3, cost of prosecution of $100, and a public defender lien of $100.
For a total of?
$618.
$618, and that's what, remember, we were talking about the cost, and you said you could pay $50 a month? And you're gonna start that in 90 days?
Yes, ma'am.
All right. Anything else from the state?
Nothing from the state, Your Honor.
Nothing from defense.
Thank you. Most importantly, Mr. Watson, you have a right to appeal the judgment and sentence of this court. Any notice of appeal must be in writing and must be filed within 30 days of the day's date. If you cannot afford an attorney for purposes of appeal, one will be appointed to you, okay? Mr. Watson, good luck, sir. All right. All right, now we're back on to my one I want to finish. Weber, is Weber here? Yes. Thank you, officer.
Yes, ma'am.
All right, Mr. Weber, you are only here because we just want to clarify some things. You had 3 cases with us, and so on one of those cases, I want to go ahead and just make sure on the record that we're clear what your sentencing is, okay?
Okay.
All right, so we're going to take that back to
CF 19-59.
I want to get the paper. Which I don't have. CF 4319. I have 18 CF 2570. And now I have CF 1959. All right. All right, and Mr. Weber, on CF 1959, could you get me information for CF 1959?
Yes. I believe it should still be up there. I'm
It
printing
is.
another
I
one.
apologize. One at a time from now on out. It's gonna follow my own rules. Give me.
What's up?
A lot of paper. All right, and Mr. Weber, that is for your count 1 of armed trespass in a structure. That's a 3rd-degree felony with a maximum sentence of 5 years. When I did your... Mr. Weber, please raise your right hand.
Do you solemnly swear or affirm the testimony you give to the court is the truth, the whole truth, and nothing but the truth, so help you God?
Your- Mr. Weber, tell me your name and date of birth.
Hunter Weber, April 25th, 1997.
Your lawyer tells me you wish to change your previously entered plea of not guilty and enter a plea of no contest on CF 1959 for count 1 of armed trespass in a structure, maximum sentence of 5 years. Is that what you wish to do today?
Yes, ma'am.
Are you under any influence of drugs, medication, or alcohol?
No, ma'am.
Are you suffering from any mental illness or emotional disturbance?
No, ma'am.
Have you been treated for those in the past?
Yes, I'm just staying out.
But you were, per your counsel for the defense, he was rehabilitated or found competent, correct?
He was found competent, restored.
Thank you. How far did you go in school?
2 years college.
Do you read and write English?
Yes, ma'am.
Do you read and understand the constitutional rights on this plea form? That plea form that we're talking about is the second plea form that you signed. If you look, it has CF 1959.
Yes, ma'am.
All right. Are these your initials on the plea form?
HW?
Thank you. And is this your signature on page 4?
Yes, ma'am.
Do you understand the maximum possibility for this offense was 5 years and $5,000?
Yes, ma'am.
Has anybody forced or threatened you and get you to enter this plea?
No, ma'am.
Has anybody promised you anything other than what your lawyer has placed on the record previously and today?
No, ma'am.
Are you satisfied with the lawyer's representation of you in this matter?
Yes, ma'am.
Do you understand by entering this plea there will be no trial, non-imposed sentence based upon this plea?
Yes, ma'am.
Do you understand if you're not a citizen of the United States of America, entry of this plea will result in deportation?
Say again?
Are you aware if you're not a citizen of the great United States, entry of this plea will result in deportation?
Yes, ma'am.
Are you aware of any DNA evidence that would exonerate you?
No, ma'am.
State,
No, Your Honor.
defense,
No.
factual basis?
Apologies, Your Honor. I had a.
No worries, we're doing it all over again, just in case there's any issues. I want to make sure that there will be nothing to come back on me for the record of not being able to understand complete the plea.
Sure. On around January 6th of 2019, the defendant was found inside property located at 14 East Lakeshore Boulevard. When they made contact with him, he had a jacket wrapped around his hand. Inside of the jacket was a knife. And he did not have permission to be at that house. All these events occurred in Osceola County, Florida.
Thank you, Mr. Weber. You do realize that you're waiving your right to PSI?
Yes, ma'am.
And do you understand what PSI is, and have you talked to your attorney about it?
Yes, ma'am.
Thank you very much. I find that I will accept your plea. I find that you are alert and intelligent, that your plea is freely and voluntarily entered, that you understand the natures of the charges that are represented by competent counsel whom you've already told me in numerous times that you're satisfied with. I find that there's a factual basis for acceptance of this plea. Is there any legal cause why this should not be a sentence? State.
No, Your Honor.
In defense, no. State, I'm sorry, I need to hear yes or no.
Nothing for the state, Your Honor. I just need to make an announcement on the other one.
What? Okay, no worries. All right, and then, when you say the other one, what, are we talking about19 CF 4319?
Yeah, Your Honor had already said it, but
So we-
defense wanted me to say it on the record, which is, I don't have a problem with it. I also have an e-filing,
I
but
thought
everything was good. I just, if they would rather hear from me, I have no problem putting it on the record.
I think what she's trying to say is she wants to announce the null process in open court of the counts.
Okay, do you think that we could just finish CF 1959 first? And then after that? Okay, cool.
It's okay.
Cool. Because that's what, I don't want Mr. Weber confused on kind of what's going on here. So we are still on CF 1959. We're still talking about your charge as far as armed trespass in a structure. And today, that charge, what I'm imposing you, is that charge has already been you've already have time served for that sentence. You are adjudicated guilty. And the only thing that's left on CF 1959 for you to do is pay costs. Madam Clerk, what are the costs in CF 1959?
Court costs $415, $3 teen court fee, cost of prosecution is $100, and a public defender lien of $100, which totals to $618.
$618 for this case. Now, you do have other cases. The good news is they're all going to run concurrent with each other as far as costs are concerned. And then you will be in 90 days, you're going to pay $50 towards all of your costs for all of your cases, which are CF 1959, 19 CF 4319, and 18 CF 2570. Any costs that you have are going to be all together, and you're going to pay $50 directly to the clerk of court in 90 days from the time you're out of jail.
Yes, ma'am.
All right.
Again, the sentence will be 553 days.
Okay, and the time served sentence?
Is 553 days.
553 days.
Thank you.
No worries. Anything further from the state or defense on this CF 1959 case?
No, Your Honor.
Nothing on the state.
All right. You have more importantly, Mr. Weber, you have the right to appeal the judgment and sentence of this court. Any notice of appeal must be in writing and must be filed within 30 days of today's date. If you cannot afford an attorney for purposes of appeals, one will be appointed to you, okay? Now, Mr. Weber, we've had a lot of things go on. Do you have any questions for me on any case?
So all my cases have been resolved, right?
Yes.
Okay. Oh, so that means I should be going home today?
I can't answer those questions from your lawyer can. Do you have any questions for me today as far as understanding any of these documents or any questions?
No, I'm just making sure all my cases are resolved. Thank you.
Okay, wait, before you leave, now, state, which case are you referring to?
On 19 CF 4319, we've already done the plea. It's already been, the disposition of everything has already been announced. I would just be announcing the no pros as to counts 3, 4, and 6. And as usual, that'll also be followed up with an e-filing from the state.
Thank you so much. Anything else for Mr. Weber, or is he free, is he free to go?
He's free to go, Your Honor.
Thank you, Mr. Weber. Good luck, sir.
Thank you.
And I'm going to lunch. We're gonna take a lunch. We're gonna take a lunch. We'll be back in the afternoon at 1:30.
They have initial appearance.
1 o'clock. Wait, what happened?
We got IA's initial appearance.
Initial appearance.
Oh, okay. Which ones do I have left?
You have 3 more left.
Burns, Sanders,
Sanders?
Sanders.
Solis.
Sanders has 2 cases. Judge McGurran has 2 cases.
Saunders.
Saunders. Apologies. Saunders.
Saunders and
So, we're
Solis, it's just 2 people?
No, Candace McGarren also on page 6. So we have 2 cases with Candace McGarren on page 6, 2 cases with Jeffrey Saunders on page 7, and 1 case with Alfredo Solis on page 8 remaining.
Let's knock it out.
They have initial appearance. They have.
At 1 o'clock?
Yes.
Sorry. Officer, at 1 o'clock, is that when you have initial appearances?
Yes.
Thank you. Let's go ahead. It's not 1 o'clock yet. Let's go ahead and take as many as we can to 1 o'clock. Appreciate it. We're going to go ahead and call the case now for Maureen Margurin Candace, 2020 CF 1424.
Matt Kazera for the state. And Your Honor, I don't know whether they need to reset that room over there and get people watching.
Oh, that's why?
Yes.
Oh, okay. I apologize, officer. Officer, you gotta tell me. You say, hey, Judge, I can't do that. I gotta set up the room for the rest, and that's okay with me. I will go ahead and reset the rest of the 3 so that you can prepare and get ready for your remaining, okay? Thank you very much, and don't ever, if you gotta do something, let me know, all right? Thank you.
Your Honor,
Back. Oh.
are you going to reset it for 2 p.m. today, or what time are we coming back? What are you?
We're gonna reset it for the next jail fee.
We're not doing it this afternoon?
Is there anyone that are not in custody right now?
The only things that are left on the docket today are in.
What, any of the inmates will be getting out today?
Well, Your Honor, there is
Excuse me, I'm sorry, did you say you're gonna, at 3 o'clock, or you're just gonna reset all 3 for?
We're finding that out right now. Give me 1 moment.
My only concern is with Mr. Solis. We have a motion to reconsider an Oritennis motion to set bond. And if the motion were granted, then he could potentially be released today. So that's really the only one that I would need recalled today. The other 2, I mean, I guess it's okay to reset them next week,
Because they're in
but,
custody,
because they're not credit time
Right,
served.
that's what I
also,
looked at.
so.
They're not credit time served, so I can reset those 2. A motion that could reconsider or tennis. Did you file a written motion?
Yes, Your Honor, I filed a written motion on
I
that.
have. Was there a motion, I can just look at this in chambers. Is there argument?
Yes, Your Honor, and there's also exhibits that I wanted to present.
Oh, then yeah, we won't have time to do that today. He's ready, and if it's exhibits, that's probably gonna mean about, at least I wanna give you your proper time.
Right, I mean, I'm fine with the court reserving ruling, or honestly, if you just want to bring him back this afternoon so we're not rushing, that might be a better course of action. It's really up to your honor. I would like for it to be heard at some point today.
I don't know, I'm pretty good, but I don't know if I'm gonna be able to do that today. If he's not, what time will we have jail feed back?
Probably 2:30, Judge?
2:30. Yeah. And I won't be available today at 3 o'clock.
Okay, in that case, so you're saying that we cannot have the hearing right now for Mr. Solis, even though it was
I'm not,
executed for?
he is, and he's the boss.
Yeah, that feed will shut off momentarily.
Yeah, they have to
Because
play.
at 1 o'clock it goes to Judge Schreiber.
Mhm.
Okay, and she's doing the IA.
I'm not even concerned about that. More importantly, what I'm hearing from him is he needs time to get these people out, to get the new people in. So I know that Judge Schreiber wouldn't probably mind me taking 1 or 2 of her moments, but this officer needs to be able to safely remove everybody and get everybody in. I want to make sure that he has ample time to do that.
All right, well, defense's concern is just that this case was docketed for a motion today, and my client was expecting to be heard on that motion, and since it is a motion for bond and we're asking for bond.
I can find to see if somebody else can hear it. No worries. I will go and ask to see if Judge Carlston can hear it, and we have a senior judge today. And this is already a motion to reconsider, so I'm sure it will take, how long do you need?
It shouldn't take any more than 10 or 15 minutes.
State?
An additional 10, 15 minutes for the state, Your Honor.
And this is 10 to 15 minutes for you, 10 to 15 minutes for her, so that's 30 minutes. Accurate?
Yes, Your Honor.
Accurate?
Yes, Your Honor.
And just to clarify, you do need the defendant present for this?
Yes.
Okay.
Mhm.
That might be the only thing getting the jail fees this afternoon for.
Oh, we can only do what we can do. We can try our best, but if you can't, we can only do what we can do. I mean, so we will try our best. What time do you think we would be able to get a jail fee?
Probably
Today.
2, depending on how many they have an initial appearance.
How many they have an initial appearance? So we'll keep it open, see how many they have an initial appearance. I'll reach out to Lisa, to Judge Munyon. Somebody will cover it. I mean, we can't hear it. We'll try our best. Anything else?
And Judge, will we get a link for this afternoon for this hearing?
They have IAs, so I don't know how long it will go. I don't really know.
Okay, no,
It's
I'm
kind of
just
up in the
curious
air.
if a new judge is, or if another judge is hearing this. I want to make sure that I'm there.
Your Honor, recommendations. I am here, and I'll be here this afternoon, and I have nothing on the docket this afternoon. I'm happy to cover for Ms. Alvera in the event that we're not able to get a Teams link up and running for whatever judge is able to handle it. I'd recommend having your JA reach out to the JAs of any other.
That's not the issue. The issue is like, what are you gonna do if the IAs run for? What are we gonna do?
I mean, that doesn't happen very often, but if it does, then we will run out of time, and we'll have to reset it for another day. But I don't want Ms. Rosas' client to have to spend another week in jail unnecessarily.
I agree, but just to be fair, this was a reconsider of a motion. Okay. So this is not an original motion to set bond. This is a oral tenants motion that was denied originally, and now the motion to reconsider the old bond motion is being heard. I just want to make that very clear, that this is not an original motion to set bond. This is a motion to reconsider an oral tenants motion that was already denied. So I will make as much accommodations as I can, as I always do. I will try my best to find someone to look at the case if we cannot. We had a lot going on today. We had 3 different, so I will try my best. Do you mind any type of exhibits being looked at? Do you want me to take the exhibits and look at them prior to?
Yes, that's fine. So if you're gonna be looking at the exhibits, then are you gonna be the one deciding the motion? Because, I mean, I think that the exhibit should go to whoever's actually gonna decide the motion.
And if I'm not, then I'll make sure it gets done to them.
And Judge, I did also submit the
Did you
score
get a
sheet.
copy of all of her exhibits?
Yes, sir.
Perfect.
And I also submitted the score sheet for the defendant.
Can you print out the score sheet really quick for me so I can give it to anyone else if they're there? And hopefully if not, then thank you very much. So I got your score sheet. I have the exhibits that were given by the defense, and IAs normally run how many hours? Hour and a half?
There's only 18 today, Your Honor.
Hour and a
Should
half.
be done in an hour.
In an hour, yeah.
About an hour and a half? Who's the IA judge?
Judge Schreiber.
Oh, well, they'll be done in an hour. Okay, that's 2:30. We'll go ahead and set it for 2:30. And we'll go from there.
And Your Honor, if the JA wouldn't mind just sending me a link and Ms. Olvera a link or just some information about what courtroom it's going to be heard in, we'll arrange to make sure that someone from the state is there at 2:30.
No worries. Thank you very much, Bess.
Thank you, Judge.
Thank you very much, Attorney Rojas.
Judge, am I bringing them back at 2:30 to 3? Or
Just Mr. Solis.
Mr. Solis, Solis.
He'll be back at 2:30?
Correct.
Okay, thank
Your Honor, regarding the other two clients of mine, Ms. McGarrett and Mr. Saunders, on the next Tuesday docket, or the next time we have the jail feed, can we put them first on the docket so that they're not, because they've both been sitting there all morning. You know, so.
I think they've been sitting there all morning because we had these 3 issues that took about 30, 40 minutes.
Oh, right. No, I'm just saying for their benefit,
Of course.
I see their body language and I understand that they're tired.
Yep, but again, taking, yes.
Well, my job is to speak for my clients.
I said, yes, I understand.
I'm always gonna look out for my clients first and foremost.
And my job is to make sure that the courtroom runs orderly and procedurally, and so that I always have to do that as well. So 30, 45 minutes to make sure that the record is clear means that sometimes on that morning docket, we may not be able to get to everybody. But to make sure that I'm getting to the most important people first, that's why we're taking Solis.
Okay.
And then if I can get to it, I'll probably do both of their pleas at 2:30. I don't want them to come back. And then depending on who covers for me, I'm gonna go ask them as well if they could just take those 2 pleas, so we won't even have to do it. If they can't, then I'll make sure that Tuesday, those are the first ones we'll take.
Okay, and then, so you want me back at 2:30?
Correct, 2:30 anyway, because.
Okay.
And then what I'm saying at 2:30, either you'll have, yes, thank you very much, guys. And at 2:30, we'll either do Solis and those other 2, or we'll do Solis and make sure that we have those other 2 come first on Tuesday morning. But if I'm gonna have somebody covered for this, I can probably have them slide in those 2.
Okay.
Andrea, should I use the same link from this morning for the 2:30?
Probably not. We just don't know. We just don't know which courtroom it's going to be heard in. So I'll work with the JA and make sure we've got you coordinating in the right courtroom.
Cool.
Thank you, I appreciate it.
All right. Yes, the detective. Yep. Yeah. Got it. Thank you. Thank you, guys. Hey, how are you? Thank you so much.
All right. Good afternoon, everyone. I'm Judge Margaret Schreiber, and we are here on first appearances. Let me let everybody know that these proceedings are being recorded. May I have appearances, please, beginning with the state?
Good afternoon. Edward Moffett on behalf of the state.
Thank you. Who's here for the Office of the Public Defender?
Jeray Reed on behalf of the Office of the Public Defender.
Thank you. And who's here for pretrial release today?
Officer Ray Okendo.
Okay, thank you. Folks, the purpose of first appearances or initial appearances is to determine whether or not you can afford legal counsel and, if appropriate, appoint legal counsel to represent you. It's to advise you of the specific charges in the case, including any allegations of violation of probation or community control. I want to let everybody know you have the right to remain silent. Anything you say can and will be used against you. You have an ongoing right to communicate with your lawyer and will be afforded reasonable means to do so. When I call your name, please step up to the podium. The purpose of IAs is to set conditions of release, not only to advise you of the charges, but to set any appropriate conditions of release. If you are here pursuant to a warrant issued out of another jurisdiction, I will not modify the terms of that warrant. So again, when I call your name, please step up to the podium. Angel Roman. So you're here based upon a warrant issued out of Miami-Dade. It's a felony probation warrant specifically referencing 7 counts for violation of probation in those underlying counts. Your bond will remain set at 0. You may be seated. Anthony Alberon. You're here based upon an out-of-county warrant issued out of Orange County, Florida. It is for a failure to appear on a petty theft, prior theft convictions count. Your bond was set at $1,000. And you may be seated. Let me back up. This is out of county, right?
Yes, Your Honor.
I'm going to go ahead and at this time appoint the Office of the Public Defender to represent everybody there in circumstances where it's appropriate. So if they don't have private counsel. All right. Dante Cartagena. You're here for, on a warrant issued out of Broward County, Florida, for a violation of your probation. Underlying charge is felony battery with great bodily harm. Your bond will remain set at $0. You may be seated. Kevin Reyes Martinez. You're here based upon a warrant issued out of Orange County, Florida for failure to appear. Underlying case is a petty theft case. Your bond is set at $500. Christian Navarro. You're here based upon a bench warrant for your failure to appear at your arraignment. Judge Jansevich set your bond at $2,000. Michael Bolu. You're here pursuant to an arrest warrant issued for criminal mischief in an amount of $1,000 or more. Probable cause was previously found. I'm advised by pretrial release that he meets the criteria for PTR. State, is there an objection to PTR with conditions?
State has no objection to pretrial release with conditions of no contact and no return to the scene of the offense.
All right. Then I will release you under pretrial release conditions with the additional criteria that you are to have no contact with the alleged victim and you are not to return to the scene of this incident. Antoine Montgomery. Sir, you're here pursuant to an arrest warrant. Charge is commission of a domestic battery by strangulation. Probable cause was previously found. Any contact with the alleged victim, PTR?
Judge, we were not able to contact the victim. We attempted, but we were unsuccessful. I'm sorry, Judge. This is Mr. Montgomery.
It is.
Yes, Judge, we were able to contact the victim. The victim is requesting no contact.
Okay. Your bond is set at $1,000. You are ordered to have no contact with the alleged victim. You are ordered not to return to the scene. If you share a residence, you may return on a one-time basis in the presence of law enforcement to gather your personal possessions. You are not to possess any weapons or firearms as a condition of your release. Nasir Muhammad.
Your Honor, the defendant has informed that he is obtaining private counsel.
Private counsel is not present today, so for purposes of IAs only, I've appointed you on a limited basis to represent him today. Sir, you are charged with failure to appear on 4 cases on a written promise. A bench warrant was issued. The underlying charges were trespass on a designated construction site, resisting an officer without violence, and your bonds were set at $5,999 on counts 1 and 3, and $1,999 on counts 2 and 4. And I'm going to leave them there for now. Christopher Quander. Sir, you are here pursuant to a bench warrant issued by Judge Young for your failure to appear at your arraignment. Underlying charge is battery on an emergency medical care provider. Your bond was set at 0. James Roberts. Mr. Roberts, you're here pursuant to a bench warrant issued by Judge Wooten. Underlying charge, or the warrant was issued for your failure to appear at a BOP status hearing. Underlying charge was fleeing, attempting to elude law enforcement at high speed with wanton disregard. Your bond was set at 0. Stephanie Jones.
I don't believe that we have that defendant in the courtroom. We do have a Cortel Jones for a VOP.
Sorry, the line got split. Cortel Jones. Cortel Stephanie Jones. Thank you, counsel. Sir, you're here based upon a violation of your probation allegation, specifically that you picked up a new offense and that you picked up 2 new offenses, driving while license suspended and reckless driving, or a lesser included offense. A warrant was issued by Judge Young, and your bond is set at Your bond is set at 0.
they gave me I was in Brevard County, and they gave me a $5,000 bond for my VOP, and I bonded out on January 27th on all 3 charges, and I still been in y'all custody this whole time. They said I wasn't even supposed to be transferred to Osceola, and a warrant was never supposed to be issued. I've been bonded.
Well, let me stop you for a second and suggest that you talk to your lawyer, because I've appointed her to represent you. This warrant was only issued on January 21st, so I am not sure about what you all just said, but you need to take it up with the presiding judge, who will certainly, if you are not in violation, address it with you at the appropriate time.
January 26th, and I paid it on January 27th.
I'm not going to modify the judge's warrant at this time.
Is that what that is? Okay.
Bring him back up, please. State, take a look at the warrant in that case, please. It is hard to read, but is it call for ROR instead of no bond? Sir, I'm going to ask you to be silent and let your lawyer speak for you. Ms. Reed, I'd ask you to take a look at it as well.
Your Honor, I don't have the warrant in front of me. All I have is the affidavit.
All right.
Since we're at the jail, we don't have access to.
All right. Well, let's confirm with the state, because I'm thinking it says ROR.
Your Honor, as I see it, it looks like the initials TY are marked on the ROR.
Which is Judge Tom Young. Okay, thank you. I'm going to amend my ruling, sir, and I'm going to release you ROR. Deborah Carrasquillo. Ma'am, you are charged with aggravated assault with a deadly weapon without intent to kill and criminal mischief in the amount of $1,000 or more. I've reviewed the charging affidavit and I find probable cause for both of those charges. Before I set your conditions of release, PTR, I don't show any contact with the alleged victim other than you've left a message.
Yes, Judge, after that, after the paper was sent to you, the victim called us. The victim is requesting no contact.
Okay. Bond is set at $2,500 on count 1, $150 on count 2. You're to have no contact with the alleged victim. My understanding is you do not reside together, so I'm also going to include a no return provision. You may not possess any weapons or firearms as a condition of your release. And that is all. Caroline DeJesus Goodrow.
She bonded, Judge.
All right, thank you.
Caroline DeJesus, she's right here.
Bonds were already paid.
Yeah, she bonded. You show that she bonded? We show she bonded. Oliver Grayson.
Your Honor, if possible, can we recall him? He was just brought in, and I haven't had a time to speak to him.
Yes.
He does have to tell me something.
We can recall him. Thank you. Ed Wink Rodriguez. Sir, you're charged with one count of battery, unlawful touching or striking, domestic in nature. I've reviewed the charging affidavit. I do find there's probable cause for the charges. Any contact with the victim?
Judge, no, the victim never called us back. We left a voicemail.
Bond is set at $1,000.
Your Honor, the PTR representative here informed that they did receive contact from the alleged victim, and she said no hostile contact and same residence.
TR?
I'm sorry, Judge, she must have called
Okay.
when I was away of the office.
All right.
Judge, it was after Officer Okendo left.
Okay, thank you. Well, then I will still set the bond at $1,000. I will order no hostile contact with the alleged victim. And I'm also going to order that you are to possess no weapons or firearms as a condition of your release.
And in terms of the residency, can he return to the home? The alleged victim also requested that they return to the same residence.
State, do you want to be heard?
At this point, the state objects to modifying to allow hostile contact or allowing the defendant to return home without sworn testimony from the victim indicating that she wishes to have those provisions. She's not present today.
Your Honor, the alleged victim has made her desires known through the officers of PTR. The defendant suffers from a mental disability, and when she called the officer, she was intending it to be a Baker Act situation, not an arrest, and that is why she's requesting that they have no hostile contact and also the same residence.
I'm going to allow him to return to the same residence. I'm going to requires a condition of release that you take all appropriately described medicine. Given that not taking the medicine may have played an issue in this case.
So just for my clarification, Your Honor, so I can convey this to the defendant, there's no hostile contact, and he can return to the residence and take his medication.
You must take prescribed medication, yes.
Thank you.
State would also request no weapons or firearms.
And no weapons or firearms.
Thank you, Your Honor.
Thank you. Wu Fontalvo Lang. We have a witness present for this case, so bear with us a second.
Hello, Your Honor.
I've appointed the Office of the Public Defender to represent you, sir.
Thank you, Your Honor.
I'll be with you in a minute, ma'am. All right, sir, you are charged with the following: aggravated battery on a pregnant woman, commission of domestic battery by strangulation, resisting an officer with violence, and battery on a law enforcement officer, firefighter, or intake officer. I've reviewed the charges. I do find there is probable cause for these charges. Before I set the conditions of release, ma'am, what is your name?
Haley Brown.
All right, you need to leave your mask on and just talk nice and loud for us.
Haley Brown.
Okay, Haley Brown?
Yes.
All right. And you're the alleged victim in this case, correct?
Yes.
I don't want you to tell me what happened. Anything you say can be used against Mr. Liang. I do have a couple of questions. Are you afraid for your personal safety?
No.
Do you want contact with Mr. Liang?
Yes.
Do you currently reside together?
Yes.
Do you want him to return to the residence?
Yes.
If he were to become violent with you in the future, would you have any hesitancy about calling 911?
No.
Is there anyone else who resides in the residence with the two of you?
No.
How long have you resided together?
2 months.
Does the state want to be heard on bond and conditions of release?
The state would just request an appropriate bond considering the facts and circumstances as it's outlined in the affidavit. I will note for court's information that Ms. Brown wasn't the person that notified law enforcement. It appears that she was uncooperative with law enforcement's investigation to these allegations, and it does raise some concerns as to Ms. Brown's safety with the defendant, and that she wasn't the person that notified law enforcement, and appears as if she's doing what she needs to do to protect herself and put herself in the safest situation moving forward. The state would request no contact with the defendant and no return to the scene of the offense.
Ms. Reed, do you care to be heard?
Yes, Your Honor, based on the alleged victim's testimony today, she did inquire that she would like to have contact with the defendant and the same resident, so I'm just asking and requesting that based on the defense, that we honor her wishes in this situation. She did inform that she will call the cops if something does go wrong, and she did also inform that she is not afraid of the defendant.
If I didn't say it, I did find probable cause for the charges. I am concerned about the allegations in the charging affidavit, ma'am, notwithstanding your testimony today. I'm concerned about your safety and the safety of your unborn child.
I mean, he takes perfectly good care of us, 100%. I would not put the risk of my child, like I would not do that, or put my child in risk. I just want him to come home.
Bond is set at $5,000 on count one, $1,000 on count two, $150 on count three, $150 on count four. I'm including the conditions of no hostile contact with the alleged victim. Hostile contact can be something as simple as yelling, screaming. It doesn't necessitate physical contact. It can be sending angry text messages or having an angry phone call. Angry text messages are yelling all caps on a phone. That in and of itself is cause to violate the conditions of release and would subject him to arrest in the event it happens. I am also ordering that he is to possess no weapons or firearms. I am I'm also finding an on-view violation of his conditions of release in 2019 CF 2895 and 2020 CF 1038. His conditions in that case, in both cases, I believe he's on probation. So I'm finding an on-view violation of his probation. One of the conditions of his probation is that he not pick up any new charges. He's done that. And at this time, both of those cases, I'm setting a zero bond. Thank you. Recalling Oliver Grayson.
Your Honor, before we recall Oliver Grayson, can we please call back Dante Cartenga? He informed that he does not want the public defenders to represent him, and he wants to handle his case pro se, and his initial appearance is pro se.
Dante Cartagena. You have an out-of-county warrant. I'm fine with that. The public defender's not appointed to represent you in this case.
I just wanted to mention in court that I've been held on that out-of-county warrant since November 26th. It's been in the system since November 26th. I had my mom contact some lawyers, and they informed my people that according to Florida statute 941.5.
Hold on, sir. Hold on.
Yes, ma'am.
According to the arrest warrant, you were arrested yesterday. So you haven't been sitting in the Osceola County Jail since last fall on this warrant.
Yes, ma'am. On November 22nd, I was arrested. On November 26th, it was put in the system that my out-of-county warrant was put in the system for a hold. I've been here for over 2 months.
In Osceola County Jail?
Yes, ma'am.
State?
Judge, I can look into it. At this point, the county that's requesting him will come and pick him up.
According to statute 941.5.
Hold on, this is not a bond hearing, counsel, or sir. I'm just trying to figure out the facts, so let's just deal with that for a second.
And Judge, we were wondering if he's being in jail with local charges and he just got served with the out-of-county case because he probably served his time with the local charges. I'm not aware of that, but that's possibly what's happening.
Well, let's look it up, because I have time and I'm curious.
Yes, Judge.
Madam Clerk, can you look him up by name and tell me what cases he's in jail on?
He doesn't come up with the full name. He doesn't come up with any cases here. Without Giovanni, I found DR cases. What's his date of birth on the booking report? 10/3/94?
Stand by. 10/3/94, correct.
Yeah. He has a close from 2015.
Are there any
DR
pending
cases?
charges?
No. Let's see, one was reopened. There's an order of contempt.
State, I need an answer from you now as to whether or not there are any charges pending that would, any new charges for which he's been in jail on.
I don't see any new charges besides the Broward County warrant. I do see on the Osceola County Jail website reference to 2015 DR 1758 PA. It's just listed as a contempt of court with a zero bond. The disposition date is listed as 11/21/2020, and there's a second column that has a disposition date of February 1st, 2021.
PGR, do you have any other information?
No, Judge, unfortunately, we do not research out-of-county cases. I do not have anything.
Officer Dunkirk on this side of the jail. Mr. Cartagena, he was actually picked up on that civil, as the state was saying, with a purge amount. So he was to remain in jail until that purge was paid, and it was paid. After local charges in Osceola County has been done, then he gets served in out-of-county.
All right. That's what I thought. Thank you. Do you understand what's going on, sir?
I understand what she's saying, but on the 26th, that hold was put in the computer. And that's when they identified that I had a hold. They stated that even if I paid that purge amount before that hold was put in the computer, which I could have paid that purge amount anytime before, yesterday or whenever it was paid.
When did you pay the purge amount?
The purge amount was paid yesterday. But had I had paid that purge amount, I was told that had I had even paid that purge amount prior to that, I still wouldn't have been released because on the 26th of November, the hold was put in the system. And
You would have been served. The warrant would have been activated, and you would have been transferred back in November to Broward County. You chose to sit in jail until yesterday, then you paid it, then the warrant was activated, and now you'll get transferred to Broward County, or wherever this other warrant is. So you were not held in the Osceola County Jail on the out-of-state warrant since November. This is a warrant out of, it is Broward, isn't it?
Broward, yes.
Out of Broward County. So you go to jail on the new charge, or the purge amount is done, then the violation of probation warrant is served once you purge to keep you in jail until such time as you're transported.
So statute 941.5 doesn't apply here.
I'm not making any rulings like that. I'm simply saying you were not held on this VOP warrant since November of 2020. You were arrested on this warrant yesterday, and you're being given your conditions of release today, and those conditions of release are application of the existing bond amount issued out of Broward County, which is a zero bond. You'll be held pending transport. You may be seated. Oliver Grayson.
Mr. Grayson also advised that he would like to be pro se.
Okay. Mr. Grayson, you are charged with robbery, sudden snatching, unarmed, criminal mischief in an amount of $1,000 or more, battery, unlawful touching or striking, and petty theft first offense. I've reviewed the charging affidavit. I do find probable cause for the charge. Your bond is set at $1,000 on count 1, $1,000 on count 2, $150 on count 3. No, make that $100 on count 3. It's a misdemeanor. And $100 on count 4. You're ordered not to possess any weapons or firearms as a condition of your release. And I'm finding a non-view violation of your probation in 2018 MM 2634, underlying charges battery, and setting your bond at 0 in that case.
Your Honor, may I have a chance to speak?
No. You can take it up with Judge Epperson.
So when's my next court date?
It'll be on demand.
Your Honor, the state would also request no contact with the identified victim in the case.
I'm also going to include the requirement that there be no contact with the alleged victim. Is there anybody whose name we have not called today? If so, raise your hand. All right. Full house. Thanks, everybody. Have a great day.
All right, good afternoon. We're on the record. This is the case of State of Florida versus Alfredo Solis. Case number is 2020 CF 600. Representing the state, please.
Hannah O'Mara on behalf of the state.
Thank you. And representing the defendant.
Rose Rosas on behalf of Mr. Solis.
All right, thanks. For purposes of the record, Mr. Solis has joined us via video at the jail facility. Mr. Solis, can you hear us okay?
A little bit.
I'll try and get closer to the microphone. Does that help any?
Can you talk now?
How about now? Did that help?
Yes, that's better.
Got it. All right, we are here on the defense's motion to reconsider an Ore Tennis motion to set bond. I've had an opportunity to take a look at the history of this case, and I think the history bears discussion, at least for record purposes. On September 3rd, 2020, there was a motion filed by the state to revoke Mr. Solis' pretrial release. Apparently, that was based on an allegation of a new law offense in 2020, CF 2088, as well as a traffic criminal case in 2019, CT 450, of which he was on probation. I'll have some questions. State, was the new law offense in 2088 filed, and was the violation of probation filed?
Yes, Judge.
All right, thanks. On September 15th, 2020, Judge Wooten conducted a hearing, revoked Mr. Solis' pretrial release, and issued no bond. On October 1st, 2020, there was a motion to quash the capias, or in the alternative, to set bond, filed by the defense. That motion was heard by Judge Wooten on October 27th, 2020. Evidence was presented in that case that was denied, and Mr. Solis was remanded on the outstanding capias. On January 4th, 2021, the defense and the state came before the court on Mr. Solis' case. That would have been Judge Munyon. After Judge Wooten's transfer out of this division, there was evidently an oral motion to set bond that was considered by Judge Munyon and denied, and we find ourselves here on the defendant's instant motion to reconsider the Ore Tennis motion to set bond. I presume that's pursuant to 3.192, the inherent authority of the trial court to reconsider its prior rulings while it still has jurisdiction. Ms. Solis, do you anticipate presenting witnesses or evidence?
No, Your Honor, just the only witness we have is Mr. Solis.
All right, thanks.
And then, well, other than that, we also do have exhibits that we presented to the state. I believe that the clerks did mark it.
All right, are any additional items of evidence that weren't previously presented in the motion to quash capias or set conditions of release filed on October 1st?
They're all exactly the same.
They're the same exhibits?
They're exactly the same. There's no updated records.
All right, thank you. So those are already entered into evidence?
Yes.
All right, thank you. All right, let's swear in Mr. Solis.
Please raise your right hand, sir. Do you solemnly swear or affirm the testimony you should give to this court is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I swear.
When you're ready, counsel.
Thank you, Judge. Mr. Solis, do you suffer from any medical issues?
Yes, I do. I brought a paragraph there I would like to read to the judge. It's possible?
Okay, that's fine, after we just get some. Okay, so you just want to read your letter?
Can I read it?
That's fine, go ahead and read it.
Okay, good afternoon, Your Honor. I would like to start by saying about my medical condition. I asked to be released on bond for the proper medical and treatment care. My medical condition is as follows. I have a one lung. My left lung was removed to a tumor, in medical terms called lower lobe lobectomy. It was removed, and I was left with on my right hand lung. With my right lung, I suffer from asthma. I suffer from bronchial asthma that I have to take antibiotics frequently, so my lung will not collapse on me due to a cold, pneumonia, etc. These antibiotics leave me with low immune systems. I am more likely to get any virus that it could be deadly to me. I take daily medication for it, and I have a machine at home that is called the nebulizer that pumps air and medicine into my lung. That I don't, if that don't work, I have to go to the emergency room for asthma shots or treatment. I need to be in a clean environment, and jail is not the place. I have a heart problem when I cannot breathe due to my asthma. My heart beats so fast that it turns into tachycardia that causes the heart attack. For this problem, I take a medicine that this jail don't offer. The medicine is called lorazepam. It's to calm my heartbeat down so it won't turn into tachycardia, heart attack. I deal with this every day. I also have liver disease due to the strong medication I take for my medical condition. My medical condition needs specialists, doctors, for medical treatment. All this that I am saying is backed by my medical records from my doctor to you, Your Honor, provided to you from my lawyer. All I ask is to be released on bond. I am not a flight risk. I have ties to my community in Osceola County. I own my own home, pay my taxes like everybody else. I show to all my court appearances, and I always surrender to the court. I would like to be released until trial due to my medical condition. I am more subject to get sick in jail than home. Your Honor.
Thank you very much, Mr. Solis. Any additional questions for Mr. Solis?
Yes, I also wanted to touch on his mental health issues and some treatment that he had done prior to being arrested. Mr. Solis, do you have any mental health issues?
Yes, I do. I take medication also for that on the outside.
Okay, what mental health issues do you suffer from?
I suffer from, when I can't breathe, it talks to like anxiety attacks. That my heart beats so fast due to the asthma, and I take lorazepam to calm my heart down so I won't get no heart attack, tachycardia.
Okay, do you have any other diagnosis?
Yes, they call it anxiety disorder, panic disorder. I can't breathe, so they call it panic disorder.
Okay, and do you see a doctor for that?
Yes, I do.
Okay,
In
how?
Charneco, a psychiatric medical center.
Okay, and how long have you been going to that medical center?
I've been going there almost all my life.
Okay.
Since I moved to this county, I bought a home in this county. I transferred from Orlando to here, the Osceola County doctor.
Okay.
In Charneco.
Okay, and prior to being arrested, did you participate in a DUI program with Aspire?
Yes, I was taking swimming classes, and I was about to finish. I needed like 4 more times or 5 the most, and I was able to get my hardship license. But then, the citation that I got, it got me twice in jail here, in which I was on bond already, and you came in the news that I was a warrant and I surrendered with you to the courts. That's why I'm here right now.
Okay. And So how long were you in this program, before you were arrested?
I was doing it every week, going to this program, and it was working until I'm here.
Okay. Did a court order you to participate in this program, or was that something that you did on your own?
I did that on my own.
Okay.
Through to the safety council. I took my classes. I got my certificates. So I took those alcohol treatment programs, and I was doing okay. It was ordered by safety council so I can get my hardship license.
Okay. And in this program with Aspire, did you have to take any random drug tests?
Yes.
Okay.
You have to take random drug tests there.
How often?
Probably once a week. They call you anytime you go there and you take a urinalysis.
Okay. And when you were out, after you were arrested the last time for the DUI case, did you drive after that? After you got out of jail for that case?
Can you repeat that, Rose?
So before your arrest, were you still driving?
No.
Like before, the motion to quash capias, I mean.
No, before my arrest, I wasn't driving.
Okay. How did you get to your doctor's appointments?
I asked my family members or taxi to go to my doctor's appointments frequently. This is frequently.
Okay. And how would you get to court?
Taxi also, or my family.
Okay. So if the judge were to agree to give you a bond, how much bond could you afford?
I can $500.
Okay.
I'll be able to pay right away.
Like $500 through a bondsman?
Yes.
Okay. So $5,000?
Yeah, that'll be fine.
Okay. Have you ever failed to appear for court?
Excuse me?
Have you ever failed to appear for court?
Never. Remember, I surrendered with you to the courts.
Right.
The last time because that's citation.
Right. I have no further questions.
Ms. Olvera, any questions of the defendant? You're on mute.
No questions, Judge. I apologize.
Thank you. Any additional witnesses or evidence, counsel?
No, Your Honor, just argument.
Thank you. State, any witnesses or evidence you wish for the court to consider?
No, Your Honor.
All right.
No, I apologize. I did submit the source sheet.
All right, thanks. I believe that we have that. Thank you, Madam Clerk. Take a quick look.
Your Honor, you can take my medical records. Everything I say is backed by my medical records, Your Honor.
All right, your medical records, Mr. Solis, are in evidence in a prior hearing, and I've been told that there's no additional medical records for the court to consider. I have reviewed those prior medical records. All right, thank you. Appears that the defense has submitted Defense Exhibit A for identification for the court's consideration. It appears to be a collection of the medical records as well as a cover sheet that appears to be a CDC synopsis on certain medical conditions. State, have you had an opportunity to take a look at this proposed item of evidence?
Yes, Judge.
Any objections?
No,
No objection, Judge.
Defense Exhibit A will be received as Defense 1 for purposes of this hearing, and the court will take judicial notice of the score sheet. Any additional witnesses or evidence from the state?
No, Judge, just argument.
All right, thanks. Defense, when you're ready.
Yes, Your Honor. So in this case, we know that we've asked the court before for to set a bond or to send conditions of release in Mr. Solis's case. At the time that we did the Ora Tennis motion to set bond, it wasn't something that was planned. It was case management conference, and Mr. Solis had begged me to please ask the judge, who was Judge Munyon at the time, for a bond, and I obliged against my better judgment because I did not have the records at the time. And so that's why I filed the motion to reconsider, because I wanted the court to be fully informed about Mr. Solis's medical issues. And I know that we brought up these medical issues when we had the motion to quash back at the end of October. However, at the time, I think that the Ninth Circuit was in a different place than it is now. At that time, we knew that we were going to be starting trials soon. I know Mr. Solis had expected to go to trial in January, but recently, towards the end of December, we found out that we were going to go back into phase 1 and that trials would be postponed until February 15th. But as we know from last time around, they gave us a date for when trials were going to start, and then it kept getting pushed back because the cases weren't going down. So our fear is that, Mr. Solis, he is intending to go to trial on this case, and because of his medical issues, he faces a significant risk from having serious complications from COVID-19, and because we don't know when we're going to have trials again, that's why we filed this motion to reconsider, given the current circumstances. Taking Mr. Solis's testimony along with the exhibits that I submitted, the reasons why he is asking for a bond is because he has well-documented medical issues. He's been a patient at Primary Healthcare Associates here in Kissimmee since 2017. During that time, he's been diagnosed with several illnesses that affect his respiratory and immune systems, including cirrhosis of the liver, bronchitis, pulmonary hypertension, asthma, and gallbladder disease. He's had lung surgery and he's had a portion of his lung removed. And in the past, these medical issues have aggravated his condition at the jail. Recently, there haven't been any issues with him, but that doesn't mean that there aren't going to be. And the CDC guidance that I had given to the court, it shows that people with lung disease, liver disease, asthma, bronchitis, and hypertension are at an increased risk of developing serious illnesses from COVID-19. In this case, Mr. Solis has legitimate medical issues that are supported by records dating back to 2017. And it's not just something that he's trying to use to get out of jail. It's a legitimate fear that he has that he could die from COVID-19 in the jail. In addition to that, I also provided some mental health records from Mindful Behavioral. Mr. Solis has been a patient with Mindful Behavioral here in Kissimmee since 2017. During that time, Mr. Solis has been diagnosed with anxiety, depression, and a panic disorder. This, in defense's mind, it might provide a window into why Mr. Solis has an issue with alcohol or has had an issue with alcohol in the past. And that brings me to the fact that Mr. Solis has demonstrated an intent while these cases have been pending. He's demonstrated an intent to work on his issues with alcohol. He was evaluated to participate in a program with Aspire, an adult DUI treatment program, back in May 14th of 2020. He chose to participate in this program of his own accord. He was not court ordered to do so. He was taking random drug tests of his own accord. So he's showing that he has taken the initiative to get additional help for his issues. And he also testified that he was not driving prior to coming in here for the motion to quash capias. He has people that can drive him to his doctor's appointments and to court. So Mr. Solis is demonstrating his commitment to not breaking the law any further. And Your Honor, the final reason is just that we believe that in the interest of justice, Mr. Solis should be getting a bond right now during these times, because I know that at the beginning of COVID, a lot of people were getting released when they had nonviolent offenses, because the idea was that we wanted to keep violent offenders in jail and try to release as many nonviolent offenders that we could. And we think that Mr. Solis is one of those people. He's not accused of any violent offenses. The offenses that he's accused of are driving related for the most part. And I understand that he has 3 cases, but ultimately, one of those is a VOP. And the reason why he was violated was for the 2 new law cases. So, so for all of these reasons, Your Honor, that's why we're asking for the court to set a bond in the amount of $5,000. Thank you, Your Honor.
Thank you. Response from the state?
Yes, Judge. The state's argument is the same as the previous previous arguments that we've had in the past, but I'll just summarize. I would like the court to note the defendant was on probation in case number 19 CT 450. He entered that plea on 7/21 of 2019 and was on DUI probation of a year. That was violated by the driving while license suspended in 20 CT or CF 600 on December 22nd of 2019. And subsequently, he was arrested for that VOP in March 2nd of 2020. He was then released on April 16th of 2020, and then picked up a third DUI with intent in case number 20 CF 288 on May 29th of 2020. He was released the same day in that case. At this point, Judge, the state would just raise the concern for the safety of the community. I understand that defense is stating that this is not a violent crime, or he does not have any violent crimes. However, he has clearly shown his disregard for his probation conditions. He's continued to pick up new law offenses, even when being on DUI probation. I understand that he's stated that he hadn't driven prior to appearing in court for his motion to quash capias. However, I would argue that's incorrect. The two new law offenses are driving related. But at this time, the state would just request that he be held no bond, Judge.
Thank you. Last word?
Yes, Your Honor. The only thing I wanted to add is that Mr. Solis, he has demonstrated that he's not a flight risk by the fact that he came to court for the motion to quash capias that he asked me to file, and he could have tried to avoid the court and try to avoid prosecution, and he knew it was very likely that the motion would get denied. But he wanted to come to court and he wanted to have the capias addressed. He's demonstrated that same commitment to come to court as long as I've known him. And what I meant by he was not driving before the motion to quash capias, I meant after he was released from jail for the DUI, and then before the motion to quash capias was issued, he was not driving, or the motion to quash capias was heard, he was not driving in between that time period. So that's all I wanted to say, Your Honor.
All right, thank you. Obviously, I'm not the trial court, and I have made myself as familiar with the facts and the procedure that's led up to this request as best that I can. I announced the procedural history at the beginning of the case. Obviously, Mr. Solis, Ms. Rosas is vigorously representing your interests here in court. She's fighting awful hard for you. She's made the arguments that there are well-documented medical issues that warrant your release on bond, that there are mental health issues that warrant your release on bond, that that you have made previous efforts to address any substance misuse issues that may or may not exist, warrants consideration for a release on bond. I note that those arguments have been considered not once but twice by two prior courts of competent jurisdiction. Both Judge Wooten and Judge Munyon considered that there is no additional information on those issues for the court to reconsider, and the court is going to find that it would be inappropriate for the court to revisit those decisions based on there being no additional information available. As to the passage of time since the initial motion to quash capias, as well as the ore tennis motion on January 4th, and the cogent argument that in the interest of justice, the court should consider a bond. The court is going to deny to exercise its discretion to grant bond on that basis. The court is completely mindful of your medical issues and the non-violent nature of the instant offense. However, it appears that based on a review, prior judges have found that your allegations that you continue to drive with whatever issues may or may not exist create a danger to the community, and I'm not going to revisit that decision. The attorney did a good job of putting your best foot forward again, but the request for bond, Mr. Solis, is denied. How much time served does Mr. Solis have?
Mr. Solis currently has 99 days.
Okay, he's almost got 100 days in state. What, is there an offer of resolution on Mr. Solis's case?
Yes, Judge, and the resolution has been communicated to defense to resolve all cases and the BOP.
So it's a package resolution on all of the issues.
Your Honor, may I say
Like
something?
I said,
You're welcome.